to the third session of the fourth International Symposium on Law and Peace. Today's session will explore the theme of gender justice and peace building, a topic of profound relevance in shaping our legal systems and driving social change. I am Sanya and John, a second-year BBLLB student.
And I am Kanishk Mehta, a first-year BBLLB student.
And we will serve as your guides through this session today.
As we commence this significant event, let us pause to appreciate the remarkable journey of Dr. Vishwanath Karad, MIT World Peace University. Rooted in the principles of education, research, and peace, MIT World Peace University has flourished over the past 4 decades, establishing itself as one of India's premier institutions with a global alumni network. It stands out for dedication and excellence and comprehensive development. Today, as we gather for this symposium, our goal is to foster meaningful dialogue, innovative ideas, and ignite lasting inspiration. The theme for the third session of the fourth International Symposium on Law and Peace is Gender Justice and Peace Building. Gender justice and peace building are essential pillars for creating inclusive, resilient, and equitable societies. Ensuring gender equality not only upholds dignity and rights, but also strengthens communities by addressing systemic barriers. Peace building complements this by fostering trust, reconciliation, and social cohesion, creating a foundation for sustainable harmony. This session will explore strategies to address gender disparities, promote inclusive dialogue, and resolve conflicts that undermine equity and peace. We are honored to welcome our esteemed panel of experts whose diverse perspectives and vast experience will guide us through this session. Their insights will illuminate pathways to advancing gender justice, fostering peace, and creating a stronger, more harmonious world. Let us look forward to a meaningful and inspiring session.
I now request Dr. Mrudula Kulkarni ma'am to kindly felicitate Advocate Ashwani Dubey sir. Request Dr. Vanishri Ramanathan ma'am to felicitate Dr. Advocate Deepak Kumar Thakur sir. I now request Dr. Mrudula Kulkarni ma'am to kindly felicitate Professor Sonia Nagarale ma'am. I now request Dr. Vanishri Ramanathan ma'am to kindly felicitate Advocate Harshvardhan Bhende sir. Request all the panelists to come together for a group photo. I request all the panelists to come together for the group photo with their brochures.
To officially commence today's event, it is my privilege to introduce Dr. Mridula S. Kulkarni ma'am, Professor of Civil Engineering and Dean of Student Affairs, to kindly deliver the welcome address.
Thank you so much. On behalf of Founder Executive President Dr. Vishwanath Karad sir, Executive President Rahul Karad sir, Vice Chancellor of MIT World Peace University Dr. R.M. Chitnis sir, Chief Academic Officer Dr. Kamtekar sir, I welcome one and all on this occasion of the International Symposium on Law and Peace. MIT World Peace University stands the legacy of last 41 years with 6 universities across India and many institutions, many courses, many students, right from the engineering, medical, law, to liberal arts, to arts, science, commerce, and many others. With this pretext, I welcome all of you for this session, which is based on gender justice and peace building. So it is my absolute honor and privilege to welcome you all on this important session with an important topic. At times when societies are increasingly recognizing the need for inclusivity, equity, equality, this gathering provides the opportunity for us to delve into the critical relationship between the gender justice and the pursuit of lasting peace. Today here we stand at the intersection of two powerful concepts, gender justice, in which about ensuring the equal rights, opportunities, and the recognition for all the genders, peace building, which is about creating sustainable and harmonious societies free from the conflict. As we know, and as we obviously see around the entire environment around us, gender inequality and the social injustice have long been the barriers to achieving the lasting peace. Gender-based violence, discrimination, and the marginalization of women and other genders which are in minority often exacerbates the conflicts and prevent the healing of and rebuilding of the societies. And in order to build peace, we must first address these deep-rooted inequities. The empowerment of women, the dismantling of patriarchal structures, replacing it by the society which is based on the recognition and the honor of the individuals, and the active participation of all the genders in peace process are essential steps towards the more just, peaceful world. If this is the peace at the individual, if there is peace at the individual level, there is peace in relationship. There is peace in family. There is peace in society, and then there is peace in universe. So all of us here, every one of us should step forward to make this change happen. We are integral part of it. We are privileged to have outstanding group of experts here, activists, practitioners with us today, who have worked on ground level and seen everything from the ground root level to the highest level, peak level. And their experience is going to definitely be very helpful for you as a learner of law and justice. These are the people who are leading the charge in advancing gender justice, contributing to the peace building efforts at various regions. So your insights, experiences, and wisdom will guide all of us, all our students, as we reflect on the ways in which we can collectively create a more inclusive and just world for all of us. Our students of law program here, I would like to say that I encourage you to think critically, creatively, to share your ideas and to the challenge the assumptions that you may be having because of the difference in the situation in which you have been brought up. Challenge your ideas. ये ऐसा क्यों है? Why it is like this? So this question you should always remember and question yourself and others as well. So work ahead of us is very urgent, but it is also one of the profound important work. So future of peace depends on how we address the gender justice in the today's life. I extend warm welcome to all of you. Let us make this session meaningful, productive, and transformative change which will begin from ourselves itself. I welcome one and all. Thank you so much.
Thank you, ma'am. I would now request the technical team to relay the session video to provide us with a glimpse of this session.
Welcome to the session on gender justice and peace building. At the heart of achieving inclusive and sustainable societies lies the critical intersection of law and gender equity. While the global community has made notable strides in recognizing the importance of gender equity, much work remains to ensure that legal frameworks and peace-building efforts fully integrate gender justice. Equality, including gender equality, is essential for lasting peace. Research shows that when women participate in decision-making, the likelihood of interstate conflict decreases. Yet, every day, women around the world face discrimination and inequality confronted by violence, abuse, and unequal treatment at work, at home, and in their communities. Women make up the majority of those living in poverty and often have fewer resources and less power compared to men. This inequality is compounded by factors such as class, ethnicity, age, and fundamentalism. It is crucial to acknowledge that discussions about gender must also encompass non-binary and trans individuals who face similar discrimination. As conflicts evolve and societal inequalities persist, marginalized genders face unique challenges. Laws that promote gender justice are vital for protecting rights, providing equal opportunities, and fostering resilient communities in post-conflict scenarios. The law can be a powerful tool for advancing gender justice. When legal systems align with the principles of gender equity, they pave the way for fair access to opportunities, safety, and dignity for all genders. As we explore how law can be harnessed to promote gender justice and peace building, together we can work towards a future where all individuals, regardless of gender, can thrive in inclusive and peaceful societies.
And delegates, to ensure the smooth flow of discussion, it is my pleasure to introduce Professor Smriti Tanwani ma'am. With 6 years of academic experience, she has taught at prestigious institutions and is passionate about topics such as digital rights, AI, and women's rights. Professor Smriti Tanwani ma'am, we warmly invite you to address the audience and set the tone for this session.
Honorable panelists, distinguished guests, on the dais, off the dais, esteemed colleagues, and my dear students, I, Smriti Tanwani, Assistant Professor, School of Law, Dr. Vishwanath Karad, World Peace University, welcome you all to Session 3 of the International Symposium on Law and Peace. As we know that the session's theme is gender justice, so we all need to understand that in the face of the global challenges that we currently encounter today, gender justice remains a key pillar, not only in promoting equality, but also in building sustainable peace and fostering long-term societal stability. Gender justice is not merely an issue of women's rights anymore. It is the pursuit of fairness and equality for all genders, recognizing that everyone, regardless of their sex, gender identity, or sexual orientation, deserves dignity, respect, and the opportunity to thrive. In the context of peace building, gender justice serves as the cornerstone of creating environments where all people, irrespective of gender, can participate in decision-making processes, contribute to social healing, and enable in rebuilding societies in the aftermath of the conflict. Peace building, at its heart, is about addressing the root causes of conflict, rebuilding institutions, and creating systems of justice that ensure long-term stability. However, this process cannot be fully effective if it excludes the lived experiences, voices, and contributions of women, the other gender minorities, and other marginalized groups. Indeed, the most enduring peace agreements and post-conflict recovery programs have been those that include and empower women along with all the other marginalized genders, yet too often these groups are sidelined and disregarded in the peace processes despite their proven ability to foster social cohesion and resilience. The importance of integrating gender perspectives into peace building and legal frameworks cannot be overstated, as we have seen in numerous conflict settings around us and across the globe. Women and gender minorities are disproportionately affected by violence, displacement, and the erosion of social infrastructure. However, they are also at the forefront of the efforts to rebuild communities, heal wounds, and promote justice. The question we must grapple with today is, how can we ensure that gender justice becomes a central component of legal systems and peace-building efforts? The legal community plays a crucial role in advancing gender justice. Laws shape the way the societies interact, how they govern, and how they heal. Legal frameworks must be designed to protect the rights of all individuals, ensuring access to justice for those who have been historically excluded. This includes combating gender-based violence, dismantling discriminatory laws, promoting equal participation in the political and economic processes, and ensuring that legal instruments like international conventions and human rights declarations are fully implemented at the national and international level. Today, we are fortunate to have a diverse and expert panel among us, bringing a wealth of experience in the field of law, gender justice, and peace building. As we engage in this discussion, let us consider not only the current gaps in our legal systems, but also the ways in which we can collaborate and innovate to build more inclusive, equitable, and peaceful societies. We must challenge outdated norms, confront biases that persist in both the law and the society, and collectively strive to create a future where peace is not just the absence of conflict, but the presence of justice for all genders. Together, through our work and advocacy, we can shape a world where gender justice is an integral part of every peace-building effort, ensuring a brighter, fairer future for all. Thank you so much. I look forward to the insightful discussion and the panel discussion we are about to have now. Thank you so much. Once again, warmly welcome everyone. Yeah.
Thank you, ma'am, for insightful words. It is my honor to introduce Advocate Ashwani Dubey sir, advocate on record at the Supreme Court of India, who brings over 2 decades of experience in diverse legal fields, including civil, criminal, arbitration, mining, corporate, and constitutional law. A passionate environmental advocate, his landmark petitions before the National Green Tribunal have driven significant reforms, particularly in addressing pollution in Singrauli, Madhya Pradesh. Notable cases such as Rini Johar versus State of Madhya Pradesh 2016 Supreme Court and Ashwani Kumar Dubey versus Union of India 2015 Supreme Court highlight his contribution to environmental sustainability, electoral reforms, and constitutional mandates. A prolific writer and media commentator, his insights on law and policy are featured in top outlets like NDTV and Hindustan Times. Recognized with prestigious honors, including the National Gaurav Award, Advocate Dubey Sir is a sought after speaker at national and international forums. His dedication to justice, environmental protection, and legal scholarship defines his exemplary career. We are honored to have Advocate Ashwani Dubey Sir with us. We warmly invite you to give your opening remarks.
Am I audible? Dignitaries on the dais, dignitaries of the dais. It is an honor and privilege to me to address all of you in this 4th International Symposium on Law and Peace. Thank you, Madam Dr. Mridula Kulkarni ji, for enlightening us that how we have to bring the change from the roots, how gender justice can only be significant, practically possible when we start eradicating it and bringing everyone on a domain from roots. Thank you, Tanvi ma'am, for this enlightening session and sending me some text. Friends, we live in a country where the Constitution is supreme. And the Constitution, as we say, is a living document. And if we see, starting from the preamble till the fundamental rights, we see that the Constitution does not discriminate on the ground of race, sex, gender, and religion. Then why do we? And if it is not, then there is a need to have a society where inclusion is supreme. And for inclusivity, what is required? The non-discriminatory attitude. The non-discriminatory attitude starts from the home, then it goes to the society, then the state, of course, plays a crucial role into it. As we see, I'm standing in the auditorium of a university which has a unique name, Peace University. And it would only be possible if we have more and more educational institutions which have a basic object to bring peace through law. We are not living in a princely states. We are not living in a state where the law of ruler is supreme, but we are living in a country where the Constitution is supreme. And when we see the Constitution, then the preamble itself says the equality of status and opportunities. Article 14 says the equality before law. Then Article 15(1), which says that forbids discrimination solely based on sex. Article 15, subclause 3 says it enables affirmative actions for the benefit of women and children. Article 16(6) ensures equality of opportunity and public employment irrespective of gender. And you must be agree that the Constitution is not discriminating. Constitution talks about the inclusivity. Article 23 prohibits human trafficking and forced labor, which disproportionately affects women and girls. Article 39, subclause A and subclause D enshrines the principles of equal pay for equal work and ensures an equal means of livelihood for both genders. And now, Article 42 advocates for just and human work conditions and maternity relief. Article 51, subclause A in F, foundational duties, which mandates the renunciation of practices derogatory to the dignity of women and emphasizes respect for women. And the 73rd and 74th Amendments Act 1992, which provided for reservation of seats in local bodies for women, ensuring their participation in grassroots level governance. I remember one thought of Dr. Swami Vivekananda, which he delivered in Khetudi. What he said, उन्होंने कहा जब तक हमारे देश की महिलाएं सशक्त नहीं होंगी, सुदृढ़ नहीं होंगी, पश्चिमी देशों की तरह शिक्षा नहीं लेंगी, भारत की सभ्यता के मुताबिक देश प्रगति नहीं कर सकता. And to have a country, developed nation, what is required, more and more women should be given education, respect, and also equal opportunity in every sphere of life. Now we are seeing that they are leading. After that, you see, there is another society, which is LGBTQI+. So now what is needed in this 21st century? The gender-neutral law. Why gender-neutral law is needed? So that the discrimination which is starting from the grassroots level can be eradicated. Why it is required? It is required to have a just, a fair society. Now we see there are various landmark judgments of the Supreme Court. Shah Bano versus Muhammad Ahmad Khan, 1985. And I would not delve deeper into that. But it's a very significant and important judgment of the Supreme Court. Then the Vishakha versus the state of Rajasthan we have seen. Then Gaurav Jain, Union of India. Joseph Shine versus Union of India. Navatesh Singh Johar, of course, you all know, where the people from third gender, they were given equal rights by the order of the Supreme Court. Then the Shaira Bano versus Union of India. Indian Young Lawyers Association versus the state of Kerala. And Justice K.S. Puttuswamy, of course, the 9 judges bench which talks about the right to privacy. Right to privacy is a fundamental right. Now moving further, if we see the gender justice as a cornerstone, of course the time in 10 minutes, and I will request my friends to just inform me if 10 minutes is complete. I would not take 11 minutes because Deepak has also come all the way from Delhi. So one is the gender justice as a cornerstone. Gender justice ensures equitable rights and opportunities for all genders by addressing systematic discrimination. It challenges cultural, legal, and institutional biases, promoting inclusivity in education, work, and governance. Achieving gender justice is essential to dismantling patriarchal structures that perpetuate inequality and hinder sustainable development in post-conflict societies. Understanding peace building, which is the important aspect. Peace building encompasses efforts to create enduring peace by addressing the root causes of conflict, fostering justice, and facilitating reconciliation. Incorporating gender perspective into peace building ensures that the unique experiences and needs of women and marginalized genders are considered, enabling comprehensive solutions that support long-term stability. Intersection of gender justice and peace building. Gender justice and peace building are interlinked as conflicts exacerbate gender inequalities and unequal societies are prone to unrest. Integrating gender equality into peace processes acknowledges the disproportionate effects of conflict of women and promote holistic recovery strategies, strengthening the foundation of enduring peace. Impact of gender justice on peace. Gender inequality undermines peace by marginalizing significant portions of society, exacerbating tensions and perpetuating cycles of violence. During conflicts, gender-based violence escalates. We have seen history, just go back 3 years, 4 years back, how women were treated, either the foreign ruler scheme or at the time of British era. So when the conflicts arises, most vulnerable treatment is given to the women. And I hope you will agree. You all are a student of law. If not, then also you have to put forward and see the history. There were instances where women were discriminated, and in conflict time, they were the most vulnerable, they were most cruelly treated. The role of women in peace building is very much important. Their involvement in peace building fosters inclusive solutions and reduces the likelihood of conflict recurrence. Research indicates that the peace agreements with women's participation are most sustainable. So we were talking about, Madam was talking about the UNSC role. Initiatives like UNSC Resolution 1325 have emphasized this role, urging states to include women in peace negotiations, decision-making, and post-conflict reconstruction processes. Legal frameworks. There are national and international legal frameworks which provide a foundation for advancing gender justice. So instruments like CEDAW, that is the Convention on Elimination of All Forms of Discrimination Against Women, 1979, and the Beijing Declaration, 1995, have emphasized this role, urging states to include women in peace negotiations, decision-making, and post-conflict reconstruction processes. Legal frameworks for gender justice. National and international legal frameworks provide a foundation for advancing gender justice. Then intersectionality in justice. Marginalized group for layered discrimination due to intersecting identities such as caste, ethnicity, or disability. Like a Dalit women in India face unique challenges that require tailored interventions. Intersectional approaches ensures that the gender justice efforts address the compound vulnerabilities of marginalized communities, fostering equitable and inclusive societies. Economic empowerment as a peace-building tool. Economic empowerment, particularly for women, contributes to social stability and peace, closing wage gaps, creating job opportunities, and supporting entrepreneurship enable women to play active role in rebuilding communities. Economic independence reduces vulnerability and fosters resilience, both critical for sustainable peace building. Case laws, I have already told. Now, challenges in gender justice and peace building. Lack of representation in peace negotiations. Women and marginalized genders are often excluded from peace processes. घरों में भी आप सभी देखते होंगे, जब कभी भी ऐसी कोई बात आती, कोई डिसीजन की, तो घर के बड़े, महिलाएं अंदर भले कहीं से सुन रही हों, लेकिन the male members takes a decision. Now society is evolving. More and more women are being considered as in taking decision in family members. But गाँव में तो हम तो खुद भी गाँव से हैं. गाँव में अभी भी यही होता है कि maximum decisions जो हैं बड़े वो male members लेते हैं. Now what is required? That is called the lack of representation. Not only job, but they are required to be actively given participation in the decision-making process inside the house also. So women, their agreements for certain decisions, and also the children who are understanding their decision will also bring peace in the society. यानी अगर marginalize नहीं करेंगे, discrimination किसी stage पर नहीं किया, तो naturally the peace will start. Now the weak enforcement of international commitments, which also comes. See, we live in a country where constitution, law supreme, but if we go to the Middle East, we have seen our neighboring countries. We have seen the Afghanistan. Afghanistan is just neighbor to us. What the women have not been allowed to go to the school. We should talk this. Why we should talk this? We are living in a 21st century where the world peace we are talking about, then how can we forget our neighbors? When the regime changed, you saw how women were treated. Now I was going through a news report. In Iraq, you see Iraq has taken a decision where a 9-year-old girl would be, the law was making that she can get married. So just see, 9 साल की बच्ची को अगर आपने शादी करने की परमिशन दे दी, you can understand her thought process. कितने छोटे बच्चे होते हैं. But we live in a country where 21 years and 18 years is the unified date, uniform date, where the child marriages are prohibited. We should feel proud. Where despite the thing that there are two kinds of laws. One laws which are made by the parliament. One arisen from the religious scriptures, the personal laws. But despite that, the diversity and unity, which is supreme. Our neighbors, बांग्लादेश की हालत किसी से छुपी नहीं है, पाकिस्तान की हालत किसी से छुपी नहीं है, श्रीलंका की हालत किसी से छुपी नहीं है. Discrimination you have seen, but भारत में देखिए, unity. We all are sitting in a disciplined manner. This is called, we live a country which is teaching the world the ethos, the values, the peace process. So feel proud to be an Indian, feel proud to be a Bharatiya, and feel proud to live in a country where women, children, marginalized communities, LGBTQI, all are being given the equal rights. And I'm sure the day will come when the peace building will start through the process of law. Nobody would be discriminated, provided those who needed their share of respect, their share in the jobs, if are given. Thank you very much. बहुत बहुत धन्यवाद. 10 मिनट से ज़्यादा बोल दिया शायद मैंने. And thank you, thank you. पेशेंस से सुना उसके लिए भी धन्यवाद, और धैर्य से नहीं सुना उसके लिए और भी धन्यवाद.
Thank you, Advocate Dubey, sir, for those enlightening and wise words. I would now like to introduce Advocate Deepak Kumar Thakur, sir. Advocate Deepak Kumar Thakur, sir, a seasoned legal professional and partner at Luthra and Luthra offices, Delhi, with over 17 years of experiences, specialized in projects, energy, and infrastructure. He excels in project structuring, pre-development, and management, particularly in public-private partnerships and private frameworks. His work spans mergers and acquisitions in renewable energy, concession contract claims, and representation at legal forums. Noteworthy projects include advising the Gujarat Maritime Board on major port developments, supporting A-System Energy's investment in India's Jaitabur nuclear project, and assisting Axion Investment Management in acquiring wind projects across South India. Additionally, he has guided Tata Power on the Mundra Thermal project and aided Digital Domain Holdings in establishing operations in India. With deep sector knowledge and strategic insight, he delivers value-driven solutions to domestic and global clients. It is indeed an honor to have you here today, sir. Now, I would like to invite sir to deliver the opening remarks.
Thank you guys, and good morning to all of you. And thank you, ma'am, and all the dignitaries here, and lovely students who have the patience to hear us the same topic they might be hearing for ages, and they might be trying to propagate also in their legal awareness camps, which is highly required, because what we see, this important topic, is not really followed on ground. And for that, we need the support of all of you, including not only from us, but all of you, to just go there, be out there, and highlight what is gender equality or gender justice. And before we commence, what is required to understand is what is gender justice. Is it just the equality, as ma'am said, or is it just the non-discriminate access to the rights and the privileges, what my friend Mr. Dubey said? So it is a combined factor of all of it. And then what becomes important to understand and analyze is that equality. How do you define that term, equality? Or how do you define that non-discriminate access? For example, if you give in households, like Mr. Dubey said, the decisions are taken by male members largely, and which practice is followed, if I would not be wrong in saying, putting a percentage, more than 90% in our society. So if that being the case, women are there, ladies are there in the society, they are well educated, in fact in many families. But why do they hesitate in doing that? Do they not have the right to convey their thoughts there? Do they not have the equal opportunity to express their thoughts there or participate in the decision-making process? Then if that being the case, if they have the right, if they have the opportunity to do so, then can it be said that they do not have the equal rights? Then in that case, I would like to say that they have the equal rights. It's just that their lack of possibly interest or lack of confidence in taking that decision, and which lack of confidence arises at many, many places, not only in the households, but in many systems, in our colleges, in our universities, in our schools, in our working system as well. So equality to that extent is always there. He cited many provisions from the Constitution, from UN directive principles. So there are provisions, then what actually lacks is the implementation. And our acceptance, self-acceptance to participate in the system, in the decision-making process. So I would rather go with the premise that equal opportunity is always there. It's just us who is lagging behind. And we must improve our decision-making process. We must have confidence that, okay, even if the decision goes wrong, so be it, but we must have that authority and ownership to own it up. Then, what comes is, whether do we need this gender justice in the real sense? Answer could be rather yes, answer could be no, but depends on the which side of the society you are looking at. Whether you are looking at the marginalized sections of the society, whether you are looking at the upper or the higher section of the society, or whether you are looking at the law colleges, or you are looking at the engineering colleges, you are looking at the education system, or you are looking at the working system. So this is a difficult answer, I would say, and the answer definitely lies in the system and the place where you are looking at this system. And whatever said and done, though I say and I believe in the fact that the equal opportunities are there, equality is there, but in the marginalized system or the marginalized society, and marginalized here does not mean the lower state of the society, but the part of the society where we live in, where the substantial part of Indian society lives in, is marginalized to that extent that where the gender is really not given that equal understanding or treatment. So there is a requirement of definitely the gender justice there. Now the third issue is, why do we need it? And who actually are the genders that we are talking about who needs this gender justice? Whether it is only the females, it is the ladies, or it is the LGBTQ community, as Mr. Dubey said, or is it men also? In our system and with the kind of recent developments, more specifically in the urban society, I won't say the rural society. Rural society, I think Mr. Bhede will deal with it because he had some concepts of the lower court experience, much higher than my experience in the lower courts. So he can deal with that aspect much better way. In the higher courts or the higher judiciary, what we see perpetually is the law being abused by the so-called marginalized sections. In many cases, not just few cases, but many cases. So that is why it requires a rather very delicate balance that we must have while dealing with the concept of gender justice. It can be very much exploited, which is being done in the urban society, I would say, by the ladies when they are not happy with the families, as in, or for one, let's not go into the fact specific cases, but they are being misused. Where it is highly required is in the lower parts of the society. And there we need this gender justice for sure. Now, if we see the evolvement of law, how it has developed over a period of time, we initially used to have this IPC, which though said that the word he will mean she also, and by way of the General Clauses Act, now, which has been replaced by Bharatiya Nyaya Sanhita, also continues the same understanding, but in clear and express words. What is now required to be understood? Whether can it be made as pure gender neutral? Answer is no, it cannot be. At least that's my view, and that's not something that has come out in any case that has been decided by any courts. And the reason for that is there are the offenses under the Bharatiya Nyaya Sanhita, which has taken from, rather relied upon largely from IPC as well. They, like there's molestation. Can you say a guy, when a male is molested, how do you prove that? How do you distinguish that fact from a girl being molested? So can it be made a gender neutral thing, law? Answer is no, it cannot be. In the instances of rapes, by way of 2013 amendment, the parliament had tried making this as gender neutral. But in real sense, how can it be made a gender neutral thing? It cannot be made. Then we have instances like offenses of 377, which has been abolished under the IPC, and now it's not there because of the Navtej Johar judgment. Now, can that offense be again, as in whether that's an offense, number one, and number two, when, as in cases of private lives, when I say private lives, I'm talking about the couples who are living in together by either by way of live-in or by way of marriage in whatsoever system. In that system, how do you distinguish whether that 377 is applied or not applied, or can be applied? So these are some of the instances where we find that these laws, more specifically the laws dealing with the society, offenses dealing with the society and the individuals, cannot be made gender neutral. And they have to be gender specific, more specifically favoring the female part. Then we come on to the concept of, I think, relative what all I have dealt with, yeah. Then we come on to the various aspects of gender neutrality, and let me know if 10 minutes is finished. So, gender neutrality, we, so gender neutrality you see at various places, starting from home part, Mr. Dubey has already dealt with, so I will not go there. Let's next come to the working place. Working place, when we talk about the service conditions, whether there has been equal rights that has been given or there is a gender sensitivity. Fortunately, in law firm life, I can say that we see more brighter faces there and we see more female participation there. Then the courts, and the courts have real challenge. Though in the higher courts, you do see some bright faces, but in the lower courts, I think that's still a challenge. And where you need to actually participate. And as a lawyer, if you need to see yourself growing as a lawyer, you need to be on the grounds and need to see the trial courts. And where we need the larger participation from the fairer side, from the brighter side. And this is because of the reason that if you participate, and Mr. Dubey rightly pointed out, if you participate, then you will bring in a lot of change in the society because you are closely connected to the family and then you can participate in the decision-making process. So that is highly required. And go out there. Trial courts are also very good. They can make your name. Then we have, because of this workplace thing, workplace gender sensitivity issue only, we have the this act that had come because of the Vishakha judgment, Prevention of Sexual Harassment, POSH Act. And then after that, we have had several instances of having the requirement of ICC, Internal Complaints Committee, and then various mechanisms in place, which now are being followed. Now, whether strictly followed, not followed, as I said, I think implementation is a big issue in terms of any law in India. So here also, that is one of the issue. And and being part of the corporate life, we have seen in many instances where the POSH Act has also been misutilized by the victims. That again, POSH Act is gender neutral is something that has to be seen. Rightfully, the Supreme Court had been coming down from time to time, not only in the this Vishakha judgment, but over a period of time in terms of the service conditions, where the female were discriminated against the continuity of services, number one. Number two, right of their eligibility in terms of pay parity, right of pension, right of toilets for that matter, in the official's workplace. Those things have also been dealt by the Supreme Court. In fact, the latest that I can recall is one of the judgments that was rendered by Justice Chanchud in the recent time, maybe 3-4 years back, was regarding giving the permanent commission to the ladies in the armed forces. So that is, again, the law is, since the law is evolving, society is evolving, so is the courts. And that can happen only if you all participate. And with that, I would like to conclude. Thank you.
Thank you, Advocate Thakur sir, for the insightful words. I would now like to introduce Professor Sonia Nagrale ma'am. Dr. Sonia Nagrale ma'am is a distinguished academic and legal professional, currently serving as Associate Professor in the Department of Law and Senior Law Officer at Savitribai Phule Pune University. With over 20 years of teaching experience, she has expertise in criminal law, human rights, constitutional law, media laws, and medical jurisprudence. Her PhD research focused on the use and misuse of parliamentary privileges in India, a need for codification. An accomplished author, Dr. Nagrale ma'am has published books like Media Law and Ethics, Legislative Privileges in India, and the upcoming A Socio-Legal Analysis of Female Genital Mutilation. Her scholarly work spans research papers, book chapters, and impactful studies on issues such as gender justice, human rights education, and marginalized communities. She has guided numerous doctoral and postgraduate students and conducted research on critical topics including biomedical waste management and interstate river disputes. Her contributions have been recognized with prestigious awards, including the C.J. Jayant Memorial Award and the Best Poster Presentation at the International Congress of Environmental Research. Dr. Nagrale ma'am is also an active consultant, mentor, and key member of committees driving curriculum development and research innovation in legal education. It is an honor to invite Dr. Nagrale ma'am, whose dedication and expertise continue to inspire the academic and legal community, for her introductory words.
Yeah, very good morning to all. Thank you for the kind introduction. Respected Mridula ma'am, Smriti ma'am, and Vaneshri ma'am, the guest speakers on the dais, and the dignitaries of the dais, and my dear students. Today the theme is about gender justice and peace building. Basically, when we speak about gender justice, I know it is, when we talk about gender equality, it is a human right which has been recognized. Even gender expression, which is very fundamental to human rights, and it has been also depicted in the Universal Declaration of Human Rights in 1948. The very first article also speaks about that all men are born equal and free. So here we speak about gender equality. Today I'm going to discuss on to rendering rights to the invisibles. That is a call to give a voice to the sexual minorities in India. So I'm going to speak on to their transgender rights. So when we speak about gender equality, we also need to look into the concept of inclusivity, and that inclusiveness would lead to a peace building ultimately. So gender equality is just not, we have to transcend from the meaning, binary meaning of male and female. We have to look into the diversity of, and that diversity speaks about transgenders. Transgenders, it is not that we are looking at transgenders with the new enactment in 2019, but yes, it was always there, and the status which was given and the respect which was given was from ancient India. And we can look into the depiction of it, into the sculptures, into the old scripts. And just not that, it was only in the British India that we could see that the Criminal Tribes Act in 1871, which basically mentioned these transgenders as criminals, and they were treated as criminals then. Just not that, but we saw that in IPC then was also Section 377. And they were considered as criminals, and it was since then that they have been ostracized, they have been secluded from the society, and there's a systemic discrimination which has been seen with regard to the transgenders in India. Looking at their position, the situation where a discrimination or discriminatory treatment has been done against them, It was only that in NALSA versus Union of India in 2014 that they got, or they were recognized as third gender. So let us not get confused between what third gender and LGBTQI++, because there was a clarification which came from the Ministry of Social Justice and Advancement that whether the third gender would also include the LGBTQI++, and the clarification which was given by the Supreme Court was that no, it would only include transgenders into it. So transgenders, which were considered, recognized to be the third gender, herein what was one very important aspect which was clarified by the Supreme Court in NALSA case was that when we speak about Article 14, it is equality before law and equal protection of laws. Therein, it is about equal protection of laws. That doesn't mean that everybody has to be treated equally. But yes, those who are similarly circumstanced, they should be treated equally. And that is where the transgenders should be treated equally. And therein, they should be treated without any kind of discrimination. Now, the word sex, which comes under Article 15 and 16, so here a very important interpretation and an expansive and extensive interpretation which was given by the Supreme Court with regard to the word sex. It does not only mean biological sex, but yes, it means gender as well. So this kind of expression, the ambit which was expanded was done in the NALSA case. It was just not about Article 15, 16, but one more thing which it spoke was about reservation. Reservation should be provided to the transgenders, that is under the socially and educationally backward classes. And under that, there should be reservation in educational institutions and in public employment as well. So this was what was expected. Of course, the implementation became sporadic. There was no implementation which was done by the states as such. When we speak about Article 15, it also states that there should be an access to public places. So here in what kind of discrimination which was seen was that the transgenders, where there is no access for them to public places, let it be restaurants or any other kind of public place. So the public health units which are there, so there has been a denial, or they have been deprived of so many aspects of life. So it is, as we see that when we talk about the fundamental values in the Constitution, and we have seen that it may not be a recent concept, but then in many of the judgments, they speak about constitutional morality. And that constitutional morality, which is based onto the fundamental values and the fundamental principles of the Constitution. So therein, if you look at it, this constitutional morality, which was mentioned by Dr. Babasaheb Ambedkar in the Constituent Assembly, he invoked Greek historian George Grote, who had first come up in his work, and he spoke about constitutional morality then. So now when we speak about constitutional morality, we speak about the declared principles in the preamble. We are talking about gender equality therein, and that gender equality, when it comes down to transgenders, herein it has been seen that they have been vehemently deprived of all these principles, all these fundamental principles and the values which has been imbibed in the Constitution. So there, when I speak about Article 21, the personal liberty aspect of it, yes, they have the right to live with dignity. As we all know that there cannot be just animal existence, and we have seen in many of the Supreme Court judgments that, and we have referred to an American judgment, that is Moon versus Illinois, where Justice Field has said that life doesn't mean that it is only about animal existence, but it goes way beyond that. So it is a life to live with dignity. So NALSA has given such broader aspect, and for the very first time, that it recognized a third gender. Looking at, then there was a legislation which came about the transgender persons' protection of rights in 2019. And therein, there were a lot of, here in Nalsa, it also spoke about one aspect about self-identification. So you can identify, self-identify your gender. When this law came up, it was criticized for the reason that when there all these directions were given in Nalsa's case with regard to the reservation, with regard to self-identification, these were not found to be there in the enactment which came in 2019. It was there that you cannot self-identify. You will have to get a certificate from the district magistrate with regard to your gender identity. So where has this concept of self-identification gone? So this kind of, this was not very much expected, and this was criticized by the transgender community very much because their own right of self-identifying was taken away. Secondly, when it spoke about reservation, so nowhere reservation in employment and educational institutions was found therein. Of course, it spoke about to have a council for them. Of course, it spoke about having redressal mechanism if at all any discrimination has been done against them. So all these aspects has been found in the Transgender Rights Protection, Transgender Persons Protection of Rights Act of 2019. So all these are there. When we compare it to America, because there has been a case where, but the law differs from state to state in America. But yes, Ojerby Fell versus Hodges case came in 2015, where it recognized the same-sex marriage and where it recognized transgenders as such. And of course, in India, we have not recognized same-sex marriage. It was Supriya Chakraborty or Supriya Chakraborty versus Union of India, where CJI, then CJI Chandrachud, sir, he therein it was not recognized, whereas in America it has been recognized. But when we look at LGBTQ and when we look at Section 377 partially being decriminalized in Navtej Singh Johhar's case. So there is a overall cases when we start from Naz Foundation to Suresh Kaushal case, and then we come down to Navtej Singh Johar. So you can look into those. I'm not getting into those judgments now. But if you look at overall the rights of the transgenders, they have been deprived of the medical access to them. So there is no inclusive policies which are being seen even after the judgment of Nalsa and then the enactment in 2019. There has to be gender or the affirmative action also has not been seen to be implemented as such. The gender affirming health care or medical care, social security, that is one very important part which has not been, it has been seen that you would see even today when I was coming on the signal, I saw transgenders begging on the signals. You must have seen, all of you must have faced. So here there is deviation towards crime, there's deviation towards, there are many, they're working as sex workers. So the healthcare system is not accessible to them. You would not see any toilets where you would see it, because whenever they have been so much secluded that you do not want them. I don't know how many of you want to, if at all when it comes to giving your house on rent, how many of you want to give it to any transgender? So there has been no access. I think the societal mind has to be changed. It is just not about the mindset of the people, the government, the institutions, the NGOs who are working out. Even the media has to bring into awareness campaigns when it comes down to the transgender rights. So therein, this deeply ingrained societal prejudices which are there about transgenders, I think that should be somewhere it has to be eliminated. And the challenges which are faced by the transgenders, that should be somewhere inclusive policies has to be brought into. some budgets and funds has to be allocated for their progress, for their promotion, and for enhancing their rights. And for this, I think we need an inclusivity of non-binary identities. We also speak about Article 19(1)(a) when we speak about expression. So they have the right of expression in forms of their behavior, of their mannerisms, of their dressing sense. So all these needs to be accepted in the society. So I think with this, I thank you all for having me here. And I hope that somewhere we go transcend the binary of having male and female and have a diverse spectrum of gender identities. Thank you so much.
Thank you, ma'am, for the enlightening words. Now, I would like to introduce Advocate Harshvardhan R. Bhende, sir. Advocate Harshvardhan R. Bhende, sir, is a distinguished advocate with over 13 years of experience, specializing in litigation, corporate advisory, and alternative dispute resolution. As the founder and principal advocate of Regulus Advocates and Consultants, Advocate Bhende, sir, has represented clients in landmark cases before the Bombay High Court, the NGT, and the NCLT. His practice spans among corporate law, environmental law, and employment law. Among his notable achievements is securing a precedent-setting case in the Supreme Court in a Supreme Court judgment for an airline ticket refund case. Beyond his legal career, Advocate Bhende, sir, is a committed philanthropist, and through the Drishan Charitable Trust, he has restored eyesight for over 150 visually impaired children, provided scholarships for blind students, and organized health initiatives impacting thousands. Advocate Bhende, sir's dedication to law and social welfare embodies his commitment to excellence and community service. Please join me in warmly welcoming him for his introductory words today. Thank you.
Thank you. Dignitaries on the dais, my esteemed senior fraternity members, Advocate Dubey, Advocate Thakur, Professor Nagrale. It's a pleasure to be sharing the dais with such august members of the legal fraternity. First of all, I express my gratitude to MITWPU for inviting me here to speak on a very sensitive topic. But as I stand here today, it puts me in a very strange position. I am the last speaker. Normally, as the last speaker, you feel like you're Kim Kardashian's last husband, because you know what you're supposed to do, but you don't know if you can make it interesting enough. So that's a bit of a dichotomy that I have. But I'm going to expand upon what the previous three speakers have actually spoken. They have gotten to the various elements of how the Constitution provides for equality, how there are various judgments of the Supreme Court which are enabling equality, enabling gender justice. But there is also a huge problem that we have. While our legislative bodies legislate, they formulate the laws, our high courts and Supreme Courts adjudicate upon these laws, they set down precedents. The problem lies on the ground. And that's where you see gender justice in its true form. We come from a land of contradictions. We come from a land where, on one end, we speak of women empowerment, we speak of equality before law, we speak of giving rights to the LGBTQ community, but at the same time, we also see a blatant misuse of the law, a blatant misuse by various sections of society. And it happens across the field. You have laws like the Sexual Harassment Act. You have laws like the DV Act. In the previous IPC, you had the 498A, which is also carried forward to the BNS. You see a grave misuse of this. And what that does is, it actually does great disservice. It does great disservice to all those genders, to all those people who are actually in need of such protection. We are seeing today a large section of men facing injustice. Now, when we speak of justice, justice always derives from equality. Justice cannot be done when there is a hyper empowerment of one section of society and a neglect towards the other. There has to be a complete equal status. There has to be an equal standing for each and every person. And therefore, I've always said this, that laws like sexual harassment need to be gender neutral, and I completely agree with my previous speakers on that. Because even men can be sexually harassed. We are seeing it on the ground. We are seeing cases coming out from various companies. We are seeing it come out from various institutions. There has to be the element of domestic violence also, which should be applicable for men, because men today also are being subjected to various forms of domestic violence. Now, when you say domestic violence, it doesn't only mean physical violence. You have to look at it from a different perspective, because the law is very clear that violence is of various types. There's physical, there's emotional, which is mental, there's also financial. So it is also the man who is facing these problems. When I spoke of on-ground issues, you have various people within the legal fraternity. And when I say legal fraternity, I specifically would indicate the judiciary. I would also indicate to the law enforcement mechanism, which is the police, which unfortunately are not intellectually equipped to understand what the real issues are. And therefore, it creates a big disparity and creates a huge influx of false cases being filed. Now, what does that do? That basically, there's a saying that a rotten apple spoils the entire apple cart. And that is what is happening. You see false cases being filed against men. You see women using the law as a tool, either to get even or to extort money. And we see this a lot in matrimonial matters. Unfortunately, the judiciary in the lower courts either are not experienced or are not sensitized enough to differentiate between what is a false case and what is a genuine case. At the same time, the law enforcement mechanisms, which is the police especially, they do not understand, or rather they are unable to fathom as to how a issue with respect to a woman, or for that respect, even an issue with respect to a person from the LGBTQ community can even arise. You have a lot of police officers who are, I call them trigger happy. They file cases because they said कि हाँ हमारा mandate है, हम file कर देंगे. But they don't really get into the investigative part of coming to the reality of what that case is all about. Whether that case or whether that complaint is arising from something which is genuine, or it is being used as a tool to harass somebody. When we work in the trial courts, unfortunately, we have certain rotten apples within our profession as well, who use these women-centric laws as a package tool. you will see lawyers, when you have a woman going to that lawyer, especially with some kind of a matrimonial discord. I don't use the word dispute. I always use the word discord. Because a dispute is something which is completely different. India and Pakistan can be in a dispute, can be in war. But a relation between a husband and wife, or a relation between a man and a woman in a live-in relationship can only be through discord. That levels of discord can vary. But due to the pure ability to file cases left, right, and center, you have a woman filing multiple cases against men. So you will have cases filed against the domestic violence, under the Domestic Violence Act. You will have the 498A. You will have maintenance applications. You will have custody applications. You will have X, Y, Z coming from all corners of our statutes. What does this do? This only puts pressure on the judiciary, because the judiciary is following a set pattern without getting into the depths, without analyzing the reality of that case. They go ahead and pass judgments. Many of these judgments get overturned by the high courts or by the Supreme Courts. Many cases in which matters under 498A are filed, you will see that the high courts would quash them because they realize that the entire complaint harbors on falsity. But this, I would always say this, that what this does is, again, it does great disservice to the real and genuine cases out there. And therefore, when we talk of gender justice, the justice must be equal. It must apply equally to everybody. Men, women, and members of the third gender. I also would go ahead and say this, that in order to achieve peace, and in order to have a proper mechanism for peace building, a sense of equality is a must, because justice and peace are synonymous with equality. Another element I would want to state here, that we come from a land which has a very old and primitive culture. We come from a land wherein we call one of our gods Ardhanari Nateshwar, which means that the god is half man and half woman, which means our forefathers, many centuries ago, knew that there is equal status. Our culture has also accepted that there is a third gender. We will see this in various texts. We'll see this across various aspects of mythology, if you would like to call it. Whether it's the Mahabharata, whether it's the Ramayana, you'll always see a member of the third gender playing a vital role in that entire story. So therefore, we have to accept that today, men, women, and the third gender are on an equal footing and have to be treated as equal footings. But at the same time, like I said, sensitization of people, sensitization as a society is very important. A society has to evolve. A society has to accept. You cannot thrust something upon a society. So you have to enable and give a mechanism to society to evolve. The moment you thrust something upon a society, it only leads to anarchy. We've seen this in the past, and if we do it again in the future, we'll only be heading towards anarchy. So when we look at equality, equality must come through societal change. It must come through not just the law, but through various and every element of society. The thing is that when we look at issues respect to women, and when we look at issues in respect to what the law says about women, who do we have sitting in the judiciary passing judgments in respect to women's rights? We have men sitting there. Where are the women? Why are women not joining the fraternity? Why are we not seeing more women in the judiciary? Why are we not seeing more women even in representation in our parliaments, in our state legislatures? In fact, even as we speak, the Maharashtra state election results are coming out. And even when you look at that, you'd only find about 8-9% of women candidates in the entire picture. How do we expect elements of law to be framed by the legislature when there is no representation of that particular community in that legislature? Now, maybe a year ago, we had the parliament passing a legislation to enable 33% of women in the parliament and in other local bodies and the state legislature. But I would also say this, that the parliament must also accept that there is a huge community of the transgenders. And therefore, even those people require representation. We are seeing people coming from various sections of society. We idolize people, women like Kalpana Chawla or Mary Kom. But we also accept, and we are acceptable of the fact that we have women or people from the transgender like Lakshmi, who has done great service. So we cannot discount any of these people. And as my previous speakers have already spoken, that the law has created an equal footing. The Constitution provides equality. It is up to us to ensure the implementation of that particular legislation. You cannot expect the administration to be doing it for you. We as students of law, and everybody sitting here, we all, including you, we continue to be students of law. The change begins with us. And unless we change, we cannot expect society to change. And the administration is only going to enable that change. You cannot expect administration to say, from tomorrow you're going to start accepting this person. It cannot happen. It has to come from within. It has to come from the absolute bottom of the pyramid. And I am sure, going forward, we will achieve something which even the world will take notice of. We have already enabled various legislations which have helped bring about some form of equality, but there is a long way to go. There are miles to go. And I am sure as we proceed forward and as we take more steps towards achieving this equality, peace is not very far away. So with this, I'd like to conclude my remarks. Thank you.
Thank you, sir, for your insightful words. Thank you to all the panel members for throwing light upon the subject of gender justice and peace building. I am sure that everyone sitting in this auditorium has benefited from your knowledge.
We have now arrived at the end of this session. The resolution. In light of our panel members' speeches and discussions today, I shall read out our resolution. Please stand up and raise your arm as I read out the resolution and say "I affirm" after the resolution is stated. We, the participants of the 4th edition of the International Symposium on Law and Peace, affirm that we call for urgent legal reforms to prevent and address gender-based violence in all societies, including the conflict zones. strengthening legal accountability, providing survivor-centered justice, and ensuring access to resources that are essential for the advancement of gender justice, building peace, and fostering societal healing and security for all affected communities. Kindly repeat, I affirm, to pass the resolution with majority. You may please take your seats.
As we come to the conclusion of this enriching session, it is now time to express our gratitude to all those who made this event a success. To deliver the vote of thanks, I am delighted to invite Dr. Vanishri Ramanathan Ma'am, Associate Professor at World Peace University, to the stage.
Respected delegates and all the participants present today, it is indeed an honor to extend the vote of thanks at the conclusion of this enriching, relevant session on gender justice and peace building as part of the International Symposium on Law and Peace. On behalf of the management of Dr. Vishwanath Karad, MIT World Peace University, and on behalf of the organizing committee of 4th International Symposium on Law and Peace, I extend my heartfelt gratitude to our esteemed speakers and panelists who have illuminated the critical intersection of gender justice and peace. Your insightful perspective have underscored the urgent need for inclusive strategies to promote justice, equality, and sustainable peace. First and foremost, I would like to express my heartfelt gratitude to Advocate Ashwini Dubey sir. Your presence and invaluable insights have shed light on the critical issues surrounding gender justice. You have eloquently emphasized that achieving gender justice is not merely a moral imperative, but also a practical necessity for building a harmonious and equitable global society. Sir was mentioning about intersectionality, inclusion, constitution, vulnerability, gender neutrality, among all. A special thanks to Advocate Deepak Kumar Thakur sir, whose address, mentions about the abuse of law in different contexts, which is very, very relevant, which set a powerful tone for these sessions. Your thought-provoking ideas has inspired all of us to rethink the contemporary approaches on gender justice and embrace transformative solutions. I also wish to express my appreciation to Professor Sonia Nagare ma'am for sharing her insightful views on rendering rights to the invisible. And she was mentions about the prejudices, discriminations, deprivations about the transgender community, and what type of an implementation is required on the ground level. I also extend my grateful gratitude to Advocate Harshavardhan Bende sir for sensitizing us about the ground reality which is happening on the ground, because legal solutions are not only enough, because context matters and the society matters. Sir, thank you, sir, for sharing that light. I would also like to express my gratitude to all of you, the audience, your presence here and engagement. Without you, this session will not be there, and which will be adding tremendous value to all of your presence here. Your interest in this symposium reflects the collective commitment in advancing gender justice as a cornerstone of peace-building efforts. Special thanks to our moderator, Professor Smriti Tanwani ma'am, for her enlightening views on these sessions today. And also thanks to Professor Mridula Kulkarni ma'am for her welcome speech. A big thank you to the organizers, especially the Department of Law, headed by Dr. Purnima Inamdar ma'am and Abhijit Deresa, for support, and all the support teams for ensuring the seamless execution of this event. Your dedication behind the scenes, many of them are working behind the scenes because the next session is coming, and all your efforts are what makes this session like this is possible. Once again, thank you all for your time and contributions. Let me conclude by some of the quotes. Policies are the hardwares, laws are the softwares, but gender justice society is the source code. So gender justice and peace building requires a multifaceted approach that integrates legal, social, and cultural dimensions. SDG reinforce the idea that gender justice is both a goal and a means in achieving the broader peace and development objectives. Let us carry forward all the discussion and momentum in today's discussion in our future endeavors. Wishing you all a pleasant day ahead. Thank you all. Thank you.
Kindly note all the students are requested to remain seated.
The second session will begin shortly.
Moment to reflect on the inspiring journey of Dr. Vishwanath Karad, MIT World Peace University. Built on the values of education, research, and peace, MIT World Peace University has, over the past 4 decades, grown into one of India's leading institutions. With alumni spread across the globe, it is known for its commitment to excellence and holistic growth. Today, as we come together for this symposium, we aim to create a space for meaningful discussions, exchange of ideas, and lasting inspiration. Our theme for the 4th session of the 4th International Symposium on Law and Peace is Legal Reforms in 21st Century. Legal education and practice today stand at the point of transformation, shaped by the demands of a rapidly evolving world. From integrating technology and navigating globalization to addressing environmental and societal challenges, the 21st century calls for legal reforms that extend beyond traditional boundaries. This session will explore how the legal profession can embrace these shifts, ensuring that we are equipped to tackle modern complexities with innovation. Let us delve into the reforms shaping the future of law and justice. We hope that the insights shared during this session will clarify the evolving landscape of legal education and inspire young legal minds to envision broader career paths and impactful roles in society. To guide us through this crucial discussion, we are privileged to have a panel of highly respected and accomplished experts with us today.
I now request Professor Novita Kalra ma'am to kindly felicitate Professor Dr. B.Gdeshmukh ma'am, Associate Professor and Principal at MMM Shankar Rao Chavan Law College, Pune. I would now like to request Professor Ayush Mishra sir to kindly felicitate Advocate Amay Ranade sir, Founding Partner, Kavish Law Offices.
I now request Professor Ayush Mishra to kindly felicitate Advocate Dheeraj Maitre, Partner, Dispute Resolution, Khaitan Legal Associates. I now request Professor Ayush Mishra to felicitate Advocate Abhishek Mittal, Assistant Vice President and Legal Counsel, Yes Bank.
Now before we move forward and start this awaited session, I would request my media team to kindly capture this moment with a group photograph of all the esteemed dignitaries and speakers. I would like to request all the panelists to stand at the front of the stage for the group photograph. Thank you, team. I would now like to request Professor Ayush Mishra, sir, to deliver the welcome address.
A very good morning to all of you, the esteemed panelists for the session. So I would like to welcome all the esteemed panelists on behalf of Dr. Vishwanath Karad, MIT World Peace University, on behalf of our founder president, Reverend Professor Dr. Vishwanath Karad sir, our executive president, Sri Rahul Karad sir, our vice chancellor, Dr. R.M. Chetnis sir, our chief academic officer, Dr. Sanjay Kamtekar sir, and all the members of Dr. Vishwanath Karad MIT World Peace University. Today, we are privileged to have this esteemed panelist comprising of Dr. B.Gdeshmukh ma'am, the principal of MMCC Law College, Advocate Dheeraj Mehtre sir, the partner at Khaitan Law Offices, Advocate Amir Ranade sir, the managing partner of Tavish Law Office, and Advocate Abhishek Mittal, the assistant vice president, Yes Bank. Now, talking about this theme is one of the most relevant theme in this current era, because now in this current era, we are seeing that how a law is changing a lot. So now taking a recent example of criminal law. So that criminal law has been amended, and now we see on daily basis there are certain amendments, be it in criminal law, be it in civil law, be it in cyber law. So the whole purpose of having this session is to basically make the students aware that what is the need of the society. Need of the society, need of the legal fraternity, how law has to be amended, which law has to be amended, and to compare the law, like what the law was in 19th century, what the law was in 20th century, and what the law should be in 21st century. So, because talking about this legal field, 50 years to 60 years down the line, law profession was never a choice. No one used to say that I want to become a lawyer. But talking about this current scenario, this current generation, like engineering, like management, law is also becoming a choice of a student. So when the student is choosing this law field, there are various avenues which a law student can pursue. So, and accordingly, there are various laws which is changing on day-to-day basis. Talking about the corporate field, many of the students are interested in the corporate field. Now we are sitting in an auditorium, but when we go out of the auditorium, we will find there is one new rule of SEBI. On daily basis, SEBI is coming up with certain rules. These are the law reforms. Law reforms doesn't mean only the acts. Even the bylaws are a part of law reforms. In every field, there are law reforms on daily basis. The student has to keep a tap on it. This is what this session is all about. And once again, I welcome all the esteemed panelists and the moderator of the session to this insightful session. Thank you.
Thank you, sir. Ladies and gentlemen, as we delve into the core theme of today's symposium, we have prepared a special session video that highlights the rationale behind this session. I now kindly request our technical team to play the session video.
Welcome to the session on legal reforms in 21st century. In the 21st century, legal reforms are reshaping the landscape of justice around the globe. From new legislations to international human rights treaties, societies are evolving toward more inclusive and equitable frameworks. Legal reforms are crucial in addressing the injustices that have persisted for centuries. Discrimination based on race, gender, and class. As technology, globalization, and social movements push forward, the need for adaptive legal systems has never been more urgent. Reforms are not just about updating laws, they are about transforming systems of power that perpetuate inequality. In the 21st century, this means dismantling structures that oppress marginalized communities and building legal frameworks that protect the most vulnerable. Through progressive legal reforms, we see the growing recognition of human rights, gender equality, and climate justice as fundamental pillars. These changes offer hope for a future where justice is not just a concept, but a reality for all. As we continue to reform laws, we must ensure that they serve the needs of all people, empowering individuals, fostering equality, and creating a future where justice is accessible to everyone. Join us as we engage in this vital conversation about the future of India's legal system.
The moderator for this session, Professor Novita Kalra ma'am, an accomplished academician and assistant professor at School of Law, Dr. Vishwanath Karad, MIT World Peace University. Professor Kalra brings with her over numerous years of academic experience and serves as the faculty in charge of the Alternative Dispute Resolution Cell at the university. Now, I would like to invite Professor Novita Kalra ma'am to share some valuable insights on today's theme.
A very good afternoon to everybody present here. First of all, I would like to welcome the esteemed panelists, the dignitaries, faculties, and my dear students. It is my honor to welcome all of you to the current session, which will have a discussion on legal reforms in 21st century as a part of the 4th International Symposium on Law and Peace. Now, as we gather here, we find ourselves at a critical juncture where discussions on reforming and modernizing our legal and judicial systems have never been more relevant. India, as we know, is a nation of immense diversity, complexity, and rapid change. As we move deeper into the 21st century, we are faced with the dual challenge of ensuring that our legal frameworks remain relevant while being inclusive, accessible, and responsive to the needs of a modern and a globalized society. However, legal reform is not merely about drafting new laws or amending the existing ones. It is also about fundamentally transforming the way justice is delivered in our country. We have to ensure that justice is swift, transparent, inclusive, and equitable. It is about making sure that the marginalized, the underprivileged, and those who have historically been denied justice can access legal remedies with ease and confidence. While I do agree that progress has been made, reforms have been done, but we must also acknowledge the fact that this path has not been easy. The true impact of these reforms can only be gauged when we consider their effectiveness in practice, their inclusivity, and their ability to address the systematic inequalities that persist. Our session today aims to shed light on key issues such as judicial reforms, access to justice, the role of technology in law, as well as the impact of legal reforms in criminal laws. We are fortunate to have a panel of esteemed experts with us today who will guide us through these complex issues and share their valuable insights on the progress we have made, the challenges we still face, and the way forward from here. I am confident that today's deliberations will not only broaden our understanding of the challenges we face, but it will also inspire actionable reforms that can make a real difference in the lives of millions of Indians. With that, I am honored to welcome the panelists to share their expertise on the theme of legal reforms in 21st century. Thank you.
Thank you, ma'am, for your inspiring words. It is my immense honor to introduce our first speaker, Professor Dr. B.Gdeshmukh ma'am, Associate Professor and Principal at MMM Shankar Rao Chavan Law College, Pune. Dr. Deshmukh is not only a principal and professor, but also a Senate member of the Savitribai Phule Pune University. She has enriched the legal community by delivering lectures at prestigious institutions and contributing extensively to research on critical topics like criminal justice, healthcare disputes, and human rights impact of terrorism. Her invaluable insights into governance transparency, challenges in legal education, and the judiciary's pivotal role in societal security have been presented at both national and international platforms. Ma'am, it is an immense privilege to have you here with us. Ladies and gentlemen, Please join me in welcoming Dr. B.Gdeshmukh ma'am to deliver her opening remarks.
Very good afternoon, everyone. My fellow panel members, faculty members of this institute, and students. First, I would like to convey my heartfelt thanks to the organizing team for allowing me to become a part of this wonderful international symposium. I think yesterday this event was inaugurated, and today, after this session, you have scheduled your valedictory program. So I hope you must have enjoyed all the session. And now we are in this panel discussion. The topic or theme of this panel discussion is legal reforms in 21st century. The first thing is that it is a very vast topic. It is very difficult to cover it in 1 hour, and unfortunately I have been allotted only 10 minutes, and also I have been assigned a duty to give opening remarks. So in 10 minutes I will actually try to give you an overview of all the legal reforms which took place in 21st century. Now, the moment or from the time when this topic was allotted to me, from that time I am thinking that this century, means 21st century, started from 2000. And if you see the very first starting point of this 2000, the new enactment came into India, that is Information Technology Act 2000. So this era, this century started from Information Technology Act. I know today's, means you all are aware that today's world is a technological world. Now we are talking about artificial intelligence. But if you see the origin, it started from Information Technology Act 2000. So it is not a time to see the pros and cons of this act or what improvements that act has already made. But if you want to talk in terms of reforms, then this century started from that act. Then another development, the major development which took place in 21st century, because we talk about constitution, we all respect our constitution, and we talk about transparent government. So pertaining to that, you will notice one of the notable change or one of the notable law which was passed by the Parliament of India, that is Right to Information Act 2005. You must have seen or you must have heard about right to information. Now the information is easily accessible. So the credit goes to this Right to Information Act. Now if I go statute by statute or law by law, it will take so much time. So we'll have to categorize these reforms. The reforms which are related to criminal justice system, the reforms which are related to women's rights, the reforms which are related to technological area. So I think my other fellow members, they are going to talk about technology and business law. So here I'll start from the criminal justice system, or I will try to brief you about the reforms which are brought in criminal justice system, our criminal justice system. You know that criminal justice system, they have many organs, like we have investigation, we have prosecution, we have judiciary, witnesses. There are so many things attached to criminal justice system. So far as if you want to see what are the major reforms, I will take you back to 2012, and I'm sure you all are aware about the brutal incidents which took place in India, that is Nirbhaya gang rape case. This Nirbhaya case made our legislator, or they, what we can say, compel the Parliament of India to rethink about our criminal justice system. After Nirbhaya's episode, the Justice J.S. Verma committee was appointed, and Justice J.S. Verma committee took overview of the entire criminal justice system and the related provisions, and they came up with wonderful suggestion, or they gave some suggestion related to the offense of rape. And if you see the post Nirbhaya, one unfortunate thing I think we will have to say that Justice Verma committee said that even though person he has committed the offense of rape, he will not be punished with death penalty. If it is a case of gang rape, then only death penalty was there. And rape means not only the offense of rape, but any offense means any sexual offense. If person has tried to commit it, then he will also be brought under the purview of section 375 and he will be prosecuted. So this was one of the major change which was brought by after the Nirbhaya's case and after the recommendation of Justice J.S. Verma committee. Then secondly, we are in criminal justice system. Now we are talking about the e-courts. Okay, earlier filing and other things, they were very difficult, but now we are promoting e-courts. We are promoting fast track court in our country. Justice J.S. Verma committee also proposed the concept of fast track court, and for Nirbhaya's case also they constituted one fast track case 3 years before. In Maharashtra also that Kathua gang rape case happened, and for that also fast track court was established. So far as this part of criminal justice system is concerned, definitely we have made lots of changes. We can also talk about the age of juvenile. Unfortunately, in Nirbhaya's gang rape case, one person, one offender, he was about to complete his majority, but just because of the age, he couldn't be prosecuted and he was considered as juvenile and he was kept out of the trial, and he got that benefit, though he was part and parcel of that heinous crime. So our criminal justice system, our lawmakers, they thought over it and they said that if any juvenile, if he is between 16 to 18 and if he is involved in the offense of gang rape, then that juvenile, in spite of his age, can be tried for that offense as an adult. This was also a major change, I think, which was brought after Nirbhaya's case. So age of juvenile was reconsidered. Then a child, if he is below the age of 12 and if he is a victim of gang rape, then all the offenders will be punished with death penalty. So related to the offense of rape, there are major changes, and definitely, but still we cannot say that we have achieved our objective, because after 2012, after Nirbhaya's case also, we have witnessed in Maharashtra many gang rape cases. You can also take the example of recent Badlapur incident which took place in Mumbai. So we cannot say that we have gone up to that extent that yes, the entire system had changed. Definitely there is lots of scope, but yes, our lawmakers, policymakers, they are taking some efforts to bring changes in the criminal justice system. So after Justice J.S. Verma committee, you all must be aware about the recent changes and the recent laws which are introduced from 1st July 2023. Which are they? Can any one of you tell? Bharatiya Nyaya Sanhita, the new law, I think you must have gone through it, and in your syllabus also you must have. So there are 3 major changes. Now thing is that these 3 new laws, we cannot talk about it right now because they have implemented from 1st July 23, and we haven't actually understood the implementation of these laws. The success rate of these laws will have to wait for some more time if you want to analyze these laws, if you want to study the case laws related to these new amended laws. But yes, this is the major change which our government has brought, lawmakers have brought, that our Indian Penal Code, Indian Evidence Act and our CRPC, they have changed it completely with new provisions, new amendments, and you must have gone through, there are gone through some provisions which talk about admissibility of e-evidences. Now you are allowed to take the witness on video conferencing, which was not allowed earlier. So like this, there are many changes brought by these new laws. Definitely, our entire system is thinking about bringing new changes in criminal justice system. So far as the offenses of terrorism and Naxalisms are concerned, there were no laws, there were no system. I have done my PhD research in terrorism law, and I have done one case study. And you must have heard about Kandahar hijack case. So when that plane was hijacked at Kandahar, and when we wanted to report the offense, we came to know that for such an offense in our criminal justice system, there is no system, there is no special court, there is no special office where we can go and launch the offense. That our entire system, they went to police station and they filed FIR for the Kandahar hijack. So you can see that the act of terrorism and Naxalism, they are taking place, and we are launching just an FIR in the police station. So that was the problem. But definitely this new IPC, New Evidence Act, they have taken care of that. And if offenses like terrorism and Naxalism and any breakdown in peace and order taking place, then they have special mechanism, and you can now directly report to the Home Ministry of India, Home Ministry of Maharashtra, and these ministries, these important bodies, they will take note of this important offense and they will interfere, and not just the police. So like this, definitely our criminal justice system is trying to bring new reforms, but I would say in conclusion that they are not sufficient. Looking at the crime rate which is taking place in the society, we will have to go far, and we'll have to take some more effective measures so that the crime rate will decrease, the problems will decrease, and the women, basically the women, they are facing so many problems. Still, she is a victim of so many problems. So definitely, we will have to reduce it by making more laws, and we'll have to make sure that they are implemented effectively. So from my side, this is about the reforms which we brought in the 21st century in criminal justice system. Thank you again for giving me an opportunity and for making me a part of this wonderful event. Thank you.
Thank you, ma'am, for your valuable insights. It is my honor to introduce Advocate Abhishek Mittal, an accomplished corporate lawyer and a distinguished banking and financial professional with over 10 years of experience in the industry. Currently serving as the Assistant Vice President and Legal Counsel at Yes Bank Limited, Advocate Mittal has earned an outstanding reputation for his expertise in stressed asset transactions, corporate litigation, and legal advisory services. Advocate Mittal's remarkable career includes experience working with leading law firms and top asset reconstruction companies in India. His professional journey boasts significant contributions to the resolution of some of India's most high-profile stressed accounts, including SR Steel and JP Infra. One of his standout achievements was his work on India's largest stressed asset transaction, overseeing the sale of a 48,000 crore loan portfolio to JC Flower Arc. Currently, he is actively involved in handling stressed asset transactions, restructuring, settlements, and associated litigation, providing innovative solutions for borrowers and financial institutions alike. Advocate Mittal's exceptional skills in drafting and negotiating contracts and ensuring regulatory compliance have solidified his position as a leader in the corporate legal domain. His dedication and insights continue to inspire and guide professionals in the banking and finance sector. Sir, we are truly privileged to have you with us today. Ladies and gentlemen, please join me in welcoming Advocate Abhishek Mittal with a big round of applause.
Thank you for such kind introduction. Good morning, everyone. Good morning to all the dignitaries present on the dais and candidates, dignitaries, and students present off the dais. It's wonderful to see such an enthusiastic crowd for today's event. My topic is on the law reforms that I will try to put it very crisp and precise on the law reforms that are there in the insolvency and the resolution sector. As everyone will agree to me that the 21st century, there are a lot of transformation, be in economy or legal landscape. As India is trying to position itself as a global economy powerhouse, it's become more imperative to have robust and forward-looking corporate laws. So, if I will talk about how the insolvency landscape has come into picture in India. If we talk about the pre-independence era, there were Provincial Insolvency Act and the Presidency Town Insolvency Act. So these two acts were catering the requirement of the provinces and the presidency towns. If there is any association of individuals or partnership firms, they can go and file the insolvency petition over there and get it resolved. After that, if we talk about post-independence, that Sikh Industries Companies Act 1985 came into picture. So that Sikh Industries Companies Act 1985 was running parallelly with the Companies Act 1956. Companies Act 1956 got amended. There were a lot of amendments in Companies Act 1956, but it got majorly amended by Companies Act 2013. So if I talk about the revival and the rehabilitation part of the companies was taken care by the Sikh Industries Companies Act, and the winding up of the companies were being taken care by the 2013 Act and 1956 Act. So for example, how the reforms have taken place. So IBC has consolidated everything under one umbrella. If there is any revival and rehabilitation, that will take place in Insolvency Act, and the winding up also take place in Companies Act. Just to put it, not all the grounds for the winding up has been given under IBC. If the company is unable to pay the debts, then it is Insolvency Act. But if there is non-compliance of the provisions of the MCA or to the filing of ROC, then it will be under the Companies Act. Still under the Companies Act. So, other than Companies Act, SICA, the laws were not consolidated at that time. So one of the reasons under SICA, the asset was always in the debtor position. So the concept of debtor in position and creditor in position came into picture under Insolvency Act, under IBC Act. So debtor, if the asset is under debtor in position, then the creditor or the banks has to file a petition to get the position. Then they can claim their rights over it. So it is a time-taking process. So IBC has come with the concept of moratorium, where under Section 14 of IBC, once the insolvency petition is admitted, that is called insolvency commencement date, then Section 14 moratorium comes into picture. It keeps the assets intact of that corporate debtor. So these are all the principles that have been enunciated under the IBC Act. Other than this, I have seen that reforms have taken place majorly through legislative committees. They are amending new act or coming up with new act, or through judicial activism. If you see under IBC, I believe that there has been lot of judgments which have propounded the principles. If we see the clean slate theory that is very important under IBC, it comes through one of the judgment. So there was once, when I was working on SR Steel, under SR Steel, we have recovered out of 49,000 CR outstanding debt the company was having towards the creditor, Out of that, we recovered with a haircut of around 7 to 10%. We recovered around 42,000 amount of that amount from the corporate debtor. But still for the 7,000, we were trying to put a rights over that guarantor. So at that time, it was going, there was one OA was filed. So this was, the promoters were Ruya brothers in this. In that, the DRT, the one OA was going on. In that OA, so we were just, at that time, the law was in 2019, law was not very clear on the corporate guarantors part. So whether two proceedings for the same debt and default can go against the corporate debtor and corporate guarantor, this was one of the issue in that. And the other was when the lenders and when the financial creditors or the creditors had recovered the amount from the corporate debtor, whether do they have any rights against the corporate guarantor? So though the judgment was in favor of the creditors, it was held and it was then upheld by many of the judgments. One of them is EARC versus Vasan Eye Care, and then BRS Ventures also. It has been held time and again that the petition can be simultaneously filed against the borrower and the creditor, borrower and the guarantor, because there is a coextensive liability between the borrower and the guarantor. So these all are the principles which were there. So one of them is right of subrogation. If you have seen the right of subrogation under the Indian Contract Act, under section 141 and 142, is very different to the right of subrogation that is there under IBC. So under IBC, they time and again they have told the same thing, that under IBC, once you have recovered the money from the corporate debtor, because it is a altogether different contract with the guarantor, you can go again, and if there is any outstanding dues, you can recover it from the guarantor as well. So I was reading, this is the 7th November judgment on SBI versus Jalan. This is one of the biggest, I believe, will be one of the biggest resolution if it happened, though I understand that it has been pushed to liquidation now. I'm talking about Jet Airways. In Jet Airways, a Supreme Court has come very heavily on the creditors this time. So the issue was on the implementation of the resolution plan. There was a resolution plan, there was terms in the resolution plan, and Jalan was a resolution applicant. It was a consortium with one of the SPV. So they were not following they have agreed to be a resolution applicant. They have put a money to be a resolution applicant, but they are not agreeing to they were not adhering to the terms and conditions of the resolution plan. So it has been held that the reforms are required, how the COC will function. The reforms are also required that the timelines, so always the timelines have been a problem for insolvency law. The reason for following the timelines is because once the corporate debtor is in default, the assets start erosioning. So the corporate debtor is not working, the assets are not in a flow. So asset quality degrades. So the money that creditor is trying to fetch out from that asset also has to go through haircut. So these all are the issues that the challenges, you can say, with every laws have challenges. These are the challenges that we are facing. So the Supreme Court has said there should be some sector-specific laws for, as there in the infra sector, we have like the home buyers are considered as financial creditors. For same, something should come for the air industry also, because there are a lot of stress in the industry at present. So other than that, if you have heard about the infrastructure, InvIT and REITs, so it was in news these days when the SEBI chairperson came into the scanner of some foreign entity, that there is some fraud in that. So InvITs come in 2014, REITs came, the SEBI has propounded the laws, the bylaws in 2014 itself. But if you see the challenges, that InvIT is not considered as a person under the IBC Act. So these are the investment pooled vehicle. If there is a default in the investment pooled vehicle, you can only go through a SARFACI, Securitization Act, or the RDB Act. So these all are the challenges that we are facing, because now everything is in the trust is being formed, SPV is there, so creditors are just, it's a mind-boggling thing, from whom to claim money, how to claim money. So these all are the challenges that, that are there in this insolvency and resolution landscape. Other than that, there is a lot to discuss about this. If I go if I talk about the SARFACI Act, SARFACI Act, as the name stands, securitization and asset reconstruction of financial asset and enforcement of security, securitization and reconstruction of financial assets and enforcement of security interest. So every word in this, securitization is a process. Securitization is a process where in pool, the bundled assets are transferred from one person to other person. The other person will, so it is through a assignment transaction. It's a transfer of debt from one bank to another ARC or a bank. There is the RBI is working like a watchdog this time. They are coming with the circulars. There is a circular on transfer of loans. There is a circular on prudential framework. If there is, so there is June 7 circular, I suggest to read that circular. That circular is a guideline at present on the restructuring of loans. If June 7 circular, they have consolidated, earlier there were 3 circulars, CDR, corporate debt restructuring, then SDR, sustainable debt restructuring, and JLF. So they have asked me to stop on this. So yeah, there are a lot of challenges and reforms required at present. If I believe in insolvency, if you see, the reforms have been made continuously. So this is how, because there will be loopholes, and to abridge those loopholes, as per the need of the society, the reforms are required to be made. So I will conclude with this note. Thank you so much. Thank you so much for giving me this opportunity.
Thank you, sir, for such enlightening words of wisdom. I take immense pleasure to introduce our next speaker, who is a distinguished legal expert with extensive experience in dispute resolution, insolvency, and intellectual property. Advocate Dheeraj Mhatre is a partner at the Mumbai office of Khaitan Legal Associates and head of the firm's dispute resolution practice. Advocate Mhatre is an alumnus of ILS Law College, Pune, and holds a diploma in intellectual property rights from the Asian School of Cyber Laws, Pune, as well as an online certification course in IP laws from WIPO. Over the past decade, he has represented numerous renowned corporate houses in high-stakes cases concerning commercial, contractual, debt recovery, insolvency, and intellectual property disputes. Specializing in pre- and post-dispute resolution strategies, he has successfully handled complex cases before various courts and tribunals across India. His expertise and strategic acumen have been instrumental in navigating intricate legal challenges for his clients. Sir, we are honored to have you, and we would love to hear your insights on legal reforms in the 21st century. I now invite Advocate Dheeraj Mhatre to deliver his opening remarks.
Good afternoon, all the panelists and the students, and thank you very much for having me for this session. Legal reforms I was asked to talk on, and mainly judicial reforms. And when we talk about reforms, the first question comes to our mind is, why are we looking at reforms? So generally, if we trace the history of last 100 years, we see a lot of reforms happening from the pre-independence era and post-independence era. Most of the laws, as we see, were actually drafted by the Britishers, and they were suiting their requirements. But now we have seen a lot of change in the country, economy, and everything, and therefore there's a need to reform the laws. So when we look at actually different laws and how they have been reformed, at times we see a very knee-jerk reaction on laws, that they are created because of certain problems that are there. Or at times we see a real vision in actually reforming the whole system to see whether that judicial reform or that particular reform in the law per se that helps the whole problem. I'm going to concentrate on very limited issue of how judicial reform or legal reforms have impacted the commercial aspect of our practice. And there is, I don't know if you have been seeing the World Bank reports or the reports that are created by the Department of Justice in India also. Now, in last 15, 20 years, and mainly after 2000, we have been seeing a lot of push for international businesses coming to India, investments coming to India. But the biggest problem that we saw in India is that the ability to enforce contract and the ease of doing business in India. So if you go on the DOJ website of India, you will find there are matrix for that, and there are rankings given and where we stand in comparison to other countries. So just to give a basic number, in around 2015, we were standing at around 178 ranking in terms of enforcement of contracts, where Singapore was the top ranking country. And for 5 years also, our ranking has only bettered to some 120 and 130 only. Similarly, in ease of doing business index, also our ranking was around 130, and now it has come to 63. Now, if you look at these two indexes and what exactly are they looking at is whether in India, if you have to enforce a contract, and as I said, I will be concentrating on commercial aspect of it. In India, if you have to enforce a contract and you have to get reliefs, not really justice, but reliefs, is that you have to see whether the courts are actually acting swiftly in providing reliefs to people who are suffering from breach of contract. The second part is enforcement, which is very important, because if we want to better in terms of ease of doing business, then we have to show that if a foreign investment is coming to India and they are investing us money and that gets into a dispute, there is an ability to actually recover that money easily, so that we can encourage more and more foreign investments. So keeping these two indices in mind, I thought we can have a discussion on mainly 2-3 important laws which were introduced in last 10-12 years, and which actually I'm being very positive about how the changes are there, but whether the implementation is not there or not, we need to see that. But definitely there are some good reforms that we have seen. I'll start with the 2015 Commercial Courts Act, which was introduced and now being implemented in various, in the entire country actually. But what Commercial Courts Act did is that it defined certain disputes as commercial disputes, or rather categorized certain disputes as commercial disputes, and created specialized courts or commercial courts within the existing court system to be able to deal with commercial disputes swiftly. So it has a system where there has to be a case management properly. Timelines are provided within which the pleadings have to be filed, when evidence has to be filed. Strict procedures are laid down. And if the Commercial Courts Act is followed, definitely a dispute can be resolved in a very swift timelines. It's unfortunate that we are seeing that it is not being implemented that strictly. However, I'm very confident that if it is implemented, we can see the commercial disputes getting enforced very quickly and swiftly. I'm not sure if in your curriculum currently you are going through Commercial Courts Act, but you will see certain provisions like summary judgment, which is there in Commercial Courts Act, which can really either decide it in the favor of the plaintiff if they have enough evidence very quickly in terms of a summary judgment, or it can also help the defendant if the case is frivolous. So Commercial Courts Act was definitely a very good and important step in terms of speedy recovery or speedy disposal of commercial disputes. The other aspect, like as the economy is growing and we are now, somebody said we are moving from third world to second world country, and we are looking at more grown economies. We are moving towards mediation. Now, mediation was, India is a very litigious country as such. So mediation was not considered as, something that people will accept, because it's very difficult to, make two people sit and agree that, okay, you can compromise on this and let's close the dispute instead of fighting for 20 years in court. But the government actually pushed for the Mediation Act to come and introduced a compulsory mediation process in commercial disputes. So in India now, if you have to file a commercial dispute and if there is no urgency in getting an interim relief, then in that case you have to go through a compulsory process of mediation, which goes on for 90 days or more depending on how mediation is going. Now, as such, in terms of law, it was an amazing law that was introduced. How the implementation is happening is something where we are seeing there are problems, because the mediators are not qualified mediators, who are, not all of them, some of them are really qualified, but not all of them are qualified. Secondly, I think, as I said, we are a very litigious society. We as lawyers have to really convince our clients that, there's no point in fighting. You don't want to spend this time in court. Instead, you want to spend this time doing business for yourself. But from my experience, I'll tell you only 20 to 30% of the clients really understand that and agree to a compromise to say that, okay, we don't want to fight in court, but rather we take a settlement and get out of the matter. In fact, I remember we had Justice Gautam Patel, who was a ex-Bombay High Court judge. He had once mentioned during one of the court hearings that, a bad settlement is much better than a good order, because ultimately in a bad settlement you have some recourse. Eventually you are receiving money, but a good order, eventually whether you'll get money or not, is absolutely debatable. So mediation was another step which I think is very welcoming, and I can see with young lawyers, they are really leaning towards mediation, because it actually disposes of the matter quickly, and we encourage to all of our clients actually to look at if there is a possibility of settlement, even if they are losing on a short-term basis, and a long-term it's really a good solution. Third law in which I really wanted to see many more amendments, and I'm hoping that there will be more amendments with the new Arbitration Conciliation Act. I think because of the model law that we followed, the law was definitely very good, but it needed a lot of changes. And I can actually, if I look at how arbitrations are going on in India, and because we do cross-border disputes also, I can see arbitrations in Singapore, I can see arbitrations in London. I can really proudly say that in India also now arbitrations are getting over within a time span of 1.5 to 2 years. And it is an amazing thing that we have experienced, and parties and the arbitrators are really keen on closing disputes. Now, which has made the practice itself very lucrative, because we can see that people are leaning towards, all contracts are, adding an arbitration clause in it, and it is really helping parties to resolve commercial disputes very quickly. And what we have seen in the new Arbitration Act that came in 2015, and now the new further amendments are coming, are the timelines that are provided for filing pleadings, timelines that are provided for closing the matter. There are fast-track arbitration processes which you can apply and close the hearing with the only basis of documents. So Arbitration Act itself was a big change in terms of a reform in India when the amendments came in 2015, and fortunately we saw the effects of the amendment. The only problem that we saw in arbitrations, that one, they are expensive, especially ad hoc arbitrations are very expensive. Two, in arbitration, even if you get an award, the enforcement has become really impossible. Now, that means that we need, many people debate about, amendment in Arbitration Act to say challenges to the award should be made easier or difficult or, very stringent, and how, because the award is being challenged in court, it takes a lot of time. I don't think there's a problem with the Arbitration Act. The problem is with the courts where the enforcement is happening. So if our enforcement machinery is good, all awards can be enforced very quickly. There is no problem in the act as such. And therefore, I think we need to look at enforcement of the awards and how we can better the enforcement machinery. Another problem that, that I have experienced, and with the new amendment in the Stamp Act in Maharashtra, we'll face a lot of problems there, is, for example, I have received an award of, let's say, 100 crore rupees. And it also includes some interest, some costs. Now, if I have to enforce the award, I have to pay court fees or stamp duty in the court for enforcement. And in some states, the court fee is actually prohibitive. There are states like Haryana, and I think Maharashtra also now will be asking for a hefty court fees. In Andhra Pradesh, Telangana, the court fees is going to 3% or 4% also. Now, which means if I'm getting a 100 crore award, I have to pay 1 crore as court fee, with no visibility on whether I will be able to enforce the award in time or not, or whether I'll be able to recover my money. So I think that is something that we need to really look at in terms of reforms. The another topic that was discussed by ma'am was e-courts. I think e-courts have been really, and thanks to COVID I say, otherwise we wouldn't have actually implemented e-courts in India. We saw only Delhi High Court being really, high-tech, and everything is online. Filing was happening even before COVID. But post-COVID, we saw all the other courts adopting e-court system. That's made life easy. It's easy for us to appear. We really enjoyed our time, during when the courts were shut, but online hearings were happening. I could appear anywhere in the country very easily. So e-court system was a very welcome measure or reform that we saw. And obviously, we want to match to the standards of any developed countries' jurisdiction, how they are doing it. And I think there is a long way to go, but introducing the e-court system itself was a really, good change that we saw. Now, some numbers that I want to discuss, and I did discuss some numbers in terms of ease of doing business and enforcement of contract index. But although I spoke about only commercial laws where reforms have happened, I think in criminal laws also reforms are required. We have seen over 35 lakh, under trial prisoners in jails, which is a very big problem. Bails are not easy to get. There is a really big need for reforming that. Out of almost 4.1 crore pending cases in India, only 1.08 crores cases are civil cases, and all the other cases, almost 3 crore cases, are criminal cases, which is the biggest problem because the courts are only clogging and there is no disposal that is happening. So I think whilst I'm very positive about the reforms that we have seen, we are in need of reforms, but I think we should welcome the reforms that have happened till now, and we should see that how we become a part of really implementing them so that the society and everybody can benefit from these reforms. But thank you very much.
Thank you, sir, for your valuable insights. Ladies and gentlemen, it is my pleasure to introduce our next speaker and an accomplished legal professional, Advocate Amay Ranade, sir. Advocate Ranade completed his bachelor's in law from the prestigious Symposium Law School, Pune, and pursued his LLM from Queen Mary University of London, specializing in investment treaty arbitrations. Since being admitted to the Bar Council of Maharashtra and Goa in 2017, he has gained diverse experience across a broad spectrum of legal practice. As a dedicated practitioner, Advocate Ranade has handled cases ranging from matrimonial disputes to civil and commercial litigation and tax-related matters. He is the founding partner of Tavish Law Offices, where he primarily focuses on advising and representing clients in areas such as commercial disputes, insolvency, intercorporate conflicts, and structuring private equity investments. His commitment to excellence and nuanced approach to dispute resolution has made him a trusted name in the legal field. We are honored to have Advocate Amay Ranade sir with us today, and we look forward to benefiting from his insights and expertise. Ladies and gentlemen, please join me in welcoming Advocate Amay Ranade to deliver his opening remarks.
A very good afternoon to my fellow co-panelists, faculty, and young students I can see in the crowd. As rightly pointed out by Dr. Kranti, when we entered the 21st century, the first piece of legislation that was brought in was the Information Technology Act. Now, the reason why this act came into effect was because the 20th century is defined as the industrial age, and thereafter, with the advent of technology, technology was used and seen rather as a barrier for doing commercial business. And eventually the reliance on technology also increased as we progress into the 21st century. And the 21st century eventually is now recognized as the age of information technology. So what I'm going to be talking about, one of the biggest reforms that has come in the 21st century is on data privacy. Now, even when we talk in terms of commercial contracts that we generally deal with, privacy is also considered between when two parties are entering into a contract. We always have a clause which is called as a confidentiality clause. So we have restrictions placed in that what kind of information can be shared specifically between the parties, and what kind of information, if required, is to be shared to parties outside the contract with subject to certain permissions and consents. So that is from a commercial perspective. So when I'm talking from a personal perspective, with the information technology reliance gaining momentum in 21st century, we've all been making use of electronic devices. Then we've also been engaged onto social media platforms, businesses such as e-commerce businesses as well, wherein when we're interacting through the medium of information technology or from electronics, there is always this communication of information initially. That communication at times also includes some private data as well, or personal data as well. So for example, if you've created an account on Facebook or on the social media platforms, you give your personal details, or if you're on Amazon, you've also shared a banking detail. These are all private data. Now, as you're all are aware, in 2017, we had the celebrated judgment of Justice Puttaswamy, where the Supreme Court, in a majority held by Justice Chandrachud, that right to privacy is a fundamental right. Obviously, the challenge was something different on the issue of the Aadhaar bill as a money bill, that aside. But the Supreme Court recognized that privacy is a fundamental right. Now, over the passage of time from 2000 to 2017, considering that there is a lot of reliance on technology for either in the private space or in the commercial space, and of course, after the Justice Puttaswamy judgment came in, the government felt the need that there should be a law governing data privacy, how it is to be protected, disclosures when warranted, and so on and so forth. So the Ministry of Electronics and Information Technology in 2017, July, I believe, they had formed the Justice Sri Krishna Committee, which proposed a draft of a bill, which was the data, it was a bill basically in 2019, which was put forth before the Parliament for discussion, the Data Protection Bill. That bill underwent scrutiny before a parliamentary committee, and of course, because of a lot of restrictions put in place, where companies who are receiving personal data, they had to follow a multitude of checks and balances, which was obviously going to become commercially inviable for them to do so. There was a lot of resistance to that. There were a lot of suggestions, and rather there was a lot of feedback given, which the government took into consideration, and then they withdrew the bill in 2019. Then again, a fresh bill based on those suggestions, recommendations, and feedbacks. Another bill was tabled in 2022, and that is where you have the DPRP, which is the digital data privacy law, which has now been passed by the Parliament last year in August. Now, that bill basically sets down your regulatory framework for governing how personal data is protected, secured, communicated, utilized, and at the same time, it also gives rights to a person who's sharing his personal data. Now, in the bill, in the act, sorry, it's not an act. In the act, you have certain definitions which are being given. So a data principal is some ordinary person like you or me who is giving or sharing personal data. The data principal has now been given a right to keep a check and balance over how his data is being used, where it is being used, how it is being utilized. Then you have a data fiduciary. A data fiduciary is someone who is collecting the data from a data principal. there are certain obligations that are being cast upon them. So in this case, a data fiduciary may be somebody who's collecting data, for example, your social media platforms, your e-commerce platforms. They have been given a set guideline or a set parameter to follow as to how you're taking the data, whether there is a valid consent that has been taken from a data principal, how you're going to be storing the data with adequate security measures implemented in place, and also ensuring that a data principal has a right to inquire about how his data is being utilized, where it is being utilized, and if a data principal wants to have his data removed, giving him the right to have the data removed from their respective servers. Then after that, you have a proposal to establish a data protection board, which is going to be a regulatory framework like how we have the SEBI for the market, securities market. The data protection board also is going to be a watchdog for all these data fiduciaries as to how they are storing data, collecting data, utilizing it, and whether there is the proper checks and balances in place, which they will obviously, as a regulatory body, they will set down those rules and regulations subsequently once the rules. Now, unfortunately, the act has been passed, but the rules have not yet been notified, so it's not yet come into effect. Then there is also provision where a data principal, if he wants to have his data inspected, modified, removed, and if the particular data fiduciary does not give his confirmation to that, then there's a redressal mechanism that's also been placed where a complaint can be forwarded. A redressal mechanism through a complaint can be forwarded to the data protection board. They will decide on that. If there is if the data principal is not satisfied, you have the provision to go to the TDSAT, which is Telecom Dispute Settlement Authority. So that kind of a redressal mechanism has also been set, which was not there before, even at the time when the Information Technology Act was there. Then the DPRP also provides for a rather a holistic, it doesn't categorize what is personal sensitive data. Now, when I'm talking about personal sensitive data, what it means is basically to help a person, or rather help anybody, any third person, to identify a particular person based on that data. So it may include your name, your date of birth, your phone number, your body dimensions, so on and so forth, helping that third person to identify you as a person. Under the old 2019 draft bill, which was subsequently scrapped, the DPRP at the moment does not give those categorizations. Like, for example, in the Information Technology Rules of 2017, which govern the security protocols to be implemented, over there is a bifurcation of what is a personally identifiable data and what is sensitive personally identifiable data. Unlike that, in DPRP, you don't have that. So that basically gives a much more, it rather cements the right of a data principal, or a data principal, correct, to ensure that each and every aspect of his personal data is secured in a manner as prescribed under the law. Then also under this, there is luckily a really good provision that's come in. It's called a voluntary undertaking. So a data fiduciary is collecting the data. Now, God forbid there is some kind of a breach or a violation of the regulatory framework by the data fiduciary. Obviously, there will be prosecution, there are penalties set forth, there are compensatory mechanisms in place. Now, if a data fiduciary wants to settle the matter, knowing very well that it has breached the framework, it has the option of giving a voluntary undertaking to the regulatory watchdog, which is the DPB. In that, if they're giving a voluntary undertaking that there is a breach, they've identified it, and if they're ready to act upon that breach, rectify that breach, they will be protected from prosecution. So if you look at it from this perspective, where in the United States, you have something called as a deferred agreement for a deferment of prosecution, where if somebody on his own admits that there has been a breach of the law, they admit, they will rectify it, as long as it's not an egregious breach or a violation, then they enter into an agreement. So similarly out here, data fiduciaries also have been given the option of entering into a voluntary undertaking with the regulatory watchdog, and that way avoid prosecution and sanction. Then at the end also, you have the central government, who's going to obviously frame the rules and regulations. They've also given to themselves, the parliament has given the powers to the government to ensure what kind of data. So under the DPRP, I'll just come back to that, I forgot I missed out on that. The DPRP recognizes that any data which is collected in India, because now that we are living in a global era, there's a transfer of data across borders. So let's say you have Facebook US, you have Facebook India. Facebook India will obviously share data to Facebook US for its servers or for whatever compliance it needs. Now, how do you ensure that the data that is generating from India is protected and secured here? So there is an obligation on data fiduciaries who are collecting data in India to ensure that the data is secured here, and it can only be transmitted outside if the law permits or if the government by notification permits. One good thing that the government has also considered is keeping some limited power with itself to block certain countries or jurisdictions where data cannot be transmitted, of course, from the perspective of security and national security and so on and so forth. Because considering how being in the digital digital information technology era, now information technology also can be used or has a potential of being used for committing crimes against a nation and its sovereignty and integrity. So this is how the DPRP has positioned itself. Right now, unfortunately, the law has not yet come into effect because the rules have not yet been formulated. But this can be seen as a very good step to keep a check and balance over how personal private data is regulated through a particular system of checks and balances, and also ensuring that the fundamental right of a person pertaining to his private data is secured. So I think this is one of the biggest reforms, hoping that it should come into effect soon. Obviously, this is also, like my other co-panelists also said, that as a new reform comes into place, it takes time for that reform to get churning into motion and then seeing what are the permutations and combinations regarding how well it is doing, where it is falling back. So we'll have to wait and see how and when the DPRP comes into effect, and then taking into consideration what all changes need to be made, which can be done subsequently. So I think this is also one of the biggest reforms that I'm looking forward to. And so I think I'll conclude at that because we're falling short of time. So thank you, everyone. Thank you to the faculty of MIT for calling me.
Thank you, sir, for sharing your invaluable experiences and perspectives. We have now arrived at the end of this session, the resolution. In light of the speeches by our panel members and discussions carried out today, I shall now read out a resolution. Please stand up and raise your hand, and at the end of the resolution, please say, "I affirm." We, the participants of the 4th edition of International Symposium on Law and Peace, hereby affirm that we shall promote law reforms that foster justice, equity, peace, and sustainability in the 21st century. We acknowledge the importance of legal systems that are adaptable, inclusive, and capable of addressing modern issues such as digital privacy, climate justice, human rights, and economic inequality. We commit to taking concrete actions towards a more just and peaceful global society. Please repeat after me. I affirm.
I affirm.
I request all of you to kindly be seated. It is my honor to invite Dr. Ganesh Kakandikar, Head of School of Mechanical Engineering at Dr. Vishwanath Karad, MIT World Peace University, Pune. It is a privilege to have him with us today, and I now invite him to deliver the vote of thanks.
Good afternoon, friends. Indeed, it is a great pleasure to be here to express our gratitude towards these experts. So as we conclude for this enlightening session on legal reforms in the 21st century, during the 4th International Symposium on Law and Peace, I am thankful to all the panelists, those who have traveled for all of us and to enlighten us. On behalf of Dr. Vishwanath Karad University, my Executive President, Professor Rahul Karad, Honorable Vice Chancellor, and the entire organizing committee for this symposium, we express our sincere gratitude towards all the panelists. Dr. B.Gdeshmukh, Principal of Shankar Rao Chauhan Law College. Ma'am, what a coincidence. In the morning I was going through that your team has performed very well in Sakal Karandak, and we could meet in the afternoon. So many congratulations for that. Then the next speaker, Advocate Abhishek Mittal from Yes Bank, Mumbai. Advocate Dheeraj Maitre from Khetan Legal Associates. Advocate Amey Ranade, founding partner for Tavish Law Offices. I'm also thankful to the moderator of this session, Professor Nuvita Kaldra, for conducting this session. I'm also thankful to all the audience who have joined here in the auditorium, all student participants. I hope you have seen the challenges and the reforms, as our panelists have enlightened us that there are a lot of cases pending. So the future is sitting in front of us. Few of you will be pleading these cases to minimize them, and maybe few of you will be in the seats of the judges even to minimize them. So I'm thankful to you also for your kind attention. So let us take it forward that the knowledge and the perspectives shared today by all these panelists, working collectively to shape our legal systems and to reflect the ideas of justice, equity, and inclusivity. Thank you all for your time, attention, dedication. Thank you so much.
I request the students to stay back for a minute. Dubey sir, followed by our Honorable Vice Chancellor, Dr. R.M. Chitnis sir. Dr. Purnima Inamdar ma'am. May I please request the dignitaries to join hands? May I please request the dignitaries to please join hands for ringing the bell of democracy, a very important moment towards the end of this two-day enriching symposium on law and peace. The bell of democracy in the field of law represents the harmonious functioning of democratic principles, the pursuit of justice, and the commitment to upholding the rule of law. A big round of applause, everyone. Thank you. I now request all the guests to proceed towards the stage for the lighting of the traditional lamp, which is a very important tradition of our country. This lighting of lamp symbolizes that we are beginning the journey from darkness to enlightened wisdom. It is indeed our honor and privilege to have such tall personalities on stage for this very auspicious occasion. I request all the dignitaries to please stand for group photo. A very big round of applause for our esteemed dignitaries, ladies and gentlemen. I request the dignitaries to please accept the chair. Thank you. Ladies and gentlemen, distinguished guests, and esteemed participants, welcome to the valedictory session of the 4th International Symposium on Law and Peace, ISLP 2024, organized by Dr. Vishwanath Karad, MIT World Peace University, Pune, Bharat. I am Professor Shubhi Trivedi, anchor for today's valedictory session. We have gathered here to share a vision to illuminate the path of peace and harmony through the lens of law. ISLP aspires to be the shining beacon bringing together the legal professionals, policymakers, thinkers, and members of the global society at large. It is a platform where we not only address the conflict resolution, but also actively engage in peace-building processes. It is my humble request to everyone to please stand for the national song Vande Mataram. I request the technical team to play the national song.
Mataram, Vande Mataram, Sujalam, Sufalam, Malayaj Sheetalam, Shasya Shamalam, Mataram, Vande Mataram, Shubhrajyosna Pulakitayamini, Pullakusumita Drumadala Shobhini, Suhasini, Sumadhura Bhashini, Sukhadam Varadam Mataram, Vande Mataram, Vande Mataram.
I request everyone to keep standing for a very special prayer, the World Peace Prayer. It is a prayer that does not talk about any caste, creed, religion, or a particular section of society. This prayer is to the Almighty for the well-being of entire humanity. I request all of you to fold your hands and close your eyes and participate in prayer.
वेद प्रतिपाद्या जय जय स्वसंवेद्या आत्मरूपा देवा तूति गणेशु सकलार्थमति प्रकाशु म्हणे निवृत्तिदासु अवधारि गोजी गुरुर्ब्रह्मा गुरुर्विष्णु गुरुर्देवो महेश्वरः गुरु साक्षात् परब्रह्मा तस्मै श्री गुरवे नमः। पूर्णमदः पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते। ॐ शान्ति शान्ति शान्तिः।
Thank you, everyone. As we reach the conclusion of the 4th International Symposium on Law and Peace 2024, I feel privileged to address you at this significant moment. Over these 2 days of the symposium, we have witnessed an extraordinary confluence of ideas, perspectives, and solutions aimed at fostering peace through the rule of law. This symposium has been a testament to the power of dialogue and collaborations. Experts from diverse fields of law, policymakers, academicians from all across the country came together to discuss critical issues, share innovative approaches, and inspire action for peace-building processes. The depth of discussions, from the changing dimensions of legal education to gender justice and peace building, to legal reforms in 21st century, and to the protection of human rights in times of crisis, has been truly remarkable and insightful for all of us. The theme for today's valedictory session, that is sensitizing legal professionals to herald peace and harmony in the world through the lens of law, is very relevant in today's time. Legal professionals hold a unique and pivotal role in shaping a society grounded in justice, equality, and peace. Their actions and decisions significantly influence public trust in the legal system and the overall harmony of communities. Sensitizing legal professionals to the broader social implications of their work is essential to promoting peace and fostering an inclusive society. Law serves as a foundation for maintaining order, resolving disputes, and protecting fundamental rights. Legal professionals, whether judges, advocates, or policymakers, must recognize that their work extends beyond the courtroom. Their role involves addressing systematic inequalities, preventing conflicts, and ensuring that marginalized voices are heard. On this note, ladies and gentlemen, as we move ahead, I would like to welcome our Honorable Vice Chancellor of MIT World Peace University, Pune, Dr. R.M. Chitnis, sir, for his welcome address.
Good evening to all of you. And good evening to all the distinguished guests, faculty, students, participants. As we gather here for the valedictory ceremony of the International Symposium on Law and Peace, it is with a profound sense of gratitude that I reflect on the remarkable sessions we have had over the last 2 days. On behalf of our founder president, Dr. Vishwanath Karad sir, and our executive president, Dr. Rahul Vishwanath Karad sir, and on behalf of all the senior members at MITWPU University, may we extend a warm welcome to Justice Naveen Sinha ji, former Judge, Supreme Court of India, Advocate Dr. Lalit Bhasin ji, former President, Bar Association of India, and Managing Partner, Bhasin and Company. We also welcome Advocate on the Record Supreme Court and author of 2 books, Honorable Ashwin Kumar Dubey ji, and all other distinguished leaders and dignitaries present here today for the valedictory ceremony of 4th ISLP. Before I go ahead, I would like to place on record that we have more than 172 programs here, degree, postgraduate, and PhD. This is appreciation for all the students in front of us right now. And as a Vice Chancellor, I have to attend all conferences happening in this all 172 courses for the inauguration and valedictory, both. Yesterday I was here for inauguration and today for valedictory. That's my responsibility, but I'm happy and I place on the record that the kind of dignity, decorum, discipline, and a pin drop silence and no mobile attitude which you have maintained for last 2 days is exemplary, and I have no qualms in saying I haven't seen in others 171 courses. So great round of applause from my side for all of you. And mind well, I don't say this in every conference. Friends, 40 years ago, our founder, President Dr. Vishwanath Karad sir, who had an earnest urge in his mind and fire in his belly, lit the fire of value-based education, and as said earlier, glorious legacy is successfully carried forward by Rahul Karad sir. NLC is the last thing which has happened, and Bharatiya Chhatra Sansad 14th episode edition is going to happen on 8th, 9th, 10th February. And we all are coming together for preparation of that. So as you complete the exam, please spare some time for the content development. And we always talk about politics in a satire format, that this is not good in our country. Let's go to stage and see. In the format of certain performance like a skit or a drama, or it could be some song, or any kind of a satire stand-up comedy. And let us record it and let the world know that we have this brightest student, who can actually analyze the loopholes of our democracy. This particular symposium has been the forum where some of the brightest minds in the field of law and peace have shared their insight in the last 2 days. And these discussions have illuminated the vital role that robust legal system play in creating and sustaining world peace. I'm sure that conversations have had highlighted, while the legal system provides the foundation for peace, it is a people, visionary leaders, empathetic policymakers, and courageous advocates who breathe life into the law. The exchange of ideas in this symposium has reinforced that the progress is only possible when we work together, transcending boundaries and uniting them for common good. And as we conclude, let me express my deepest appreciation to everyone who contributed to make this 4th ISLP a grand success. To our distinguished guests, we thank you for your invaluable time, and you are going to enlighten us with your expertise and wisdom. To the organizing team of School of Law, your meticulous planning and dedication, along with all students volunteers, may I place on record Vice Chancellor's Office appreciation. And you are the real backbone of this symposium, my dear students. And Congratulations to all the participants on your engagement, questions and answers, and ideas that have enriched your discussion immeasurably. Once again, thank you for the kind of a dignity, decorum you have maintained. And this is the last 90 minutes valedictory session, and we have three important, eminent personalities in the field of law from our country. You can listen to them very peacefully and ask questions if you have any on your mind. I will see you again in next ISLP 2025. Thank you. Jai Hind, Jai Bharat.
Thank you, sir, for your enlightening address. As per our tradition of this country and this platform, I would request our Honorable Vice Chancellor, sir, Dr. R.M. Chitnis, sir, to felicitate the Chief Guest, Honorable Justice Naveen Sinha, sir, former Judge, Supreme Court of India. I request, sir, to felicitate Advocate Dr. Lalit Bhasin, sir. A big round of applause, everyone. I request, sir, to please felicitate Advocate Ashwini Dubey, sir, Advocate on Record, Supreme Court of India, and author of two very well-known books, Breaking the Colonial Laws and Article 32. Thank you, sir. As we all are aware that for the first time in the history of independent Bharat, an exclusive platform for the legislators, that is MLAs and MLCs, who are the lawmakers of our country, was created with the vision of our Honorable Executive President, Dr. Rahul V. Karad, sir. The first historic conference of national legislators was convened in Mumbai last year, where about 1,800 legislators across all political parties and from all states of India had gathered and extensively deliberated over the issues and challenges related to democracy, governance, development, and opportunities of collaboration. It is my humble request to our technical team to play a short film on First National Legislators Conference.
you desire for the welfare of a person, this constitution paves a way for you to achieve your goal.
Thank you, team. And as we move forward, we have with us Advocate Ashwini Dubey, sir, who is an advocate on record, Supreme Court of India, and author of 2 very well-known books, Breaking the Colonial Laws and Article 32. It is my humble privilege to invite sir for his address. May I have a big round of applause, everyone.
Thank you very much, ma'am. It is an honor and privilege to speak in front of such an erudite scholars, legal luminaries sitting on the dais, Honorable Mr. Justice Naveen Sinha, whose role in bringing technology in legal field, either in Patna High Court, Chhattisgarh High Court, and Rajasthan High Court, is much appreciated at a time when technology was just evolving with the country. Thank you, sir. A legal scholar, a name which doesn't need any recognition, Dr. Lalit Bhasin, a senior advocate of Supreme Court of India and having vast experience of more than 50 years. We are just small children in front of him. Thank you, sir, for giving me opportunity to speak in front of you. 62 years, so big round of applause for him. Professor Dr. Vishwanath D. Karad, a name which doesn't need any recognition but need respect, and his life is devoted to the country for bringing a platform where a world peace, an object of having a general neutral society, is paramount. In his absentia, we welcome him. Shri Rahul V. Karad, Executive President in absentia. Dr. Purnima Inamdar ma'am, Associate Dean, the great scholar. Dr. Arun Chitnis, Vice Chancellor, and my friend, Dr. Abhijit Dhere, and Dr. Ayush Mishra. While in the morning delivering a lecture, I noted 3 points. One point, that when I entered in the campus, because I am also youth, you all are youth, and dignitaries on that dais, of course, they have to bless us. I found that we are seeing the freedom of expression in wrong interpretation in universities, various campuses of the country, was not here. A very disciplined students and atmosphere moment we entered the campus, I found vibrating, the positive vibes. So of course, it's all efforts of the faculty members, and your support has made this university a wisdomful university, the world peace university. And I'm sure when you all of you will come in your life and will start your career, you will teach, preach, propagate, and practice the peace. We are celebrating 75th year of the Constitution, adoption of Constitution. You know, when we say the 4 fathers of the Constitution, 389 members of the Constituent Assembly, but we must say they are the architects because there were 11 mothers also. 11 mothers, Ammu Swaminathan, Annie Mackerran, Begum Azaz Rasool, Dakshayani Veladhi, Durgabai Deshmukh, Hansa Jivraj Mehta, Kamla Chaudhary, Leela Roy, Malti Chaudhary, Purnima Banerjee, Rajkumari Amrit Kaur, Renuka Ray, Sarojini Naidu, Sujata Kriplani, and Vijay Lakshmi Pandit. We must remember them, we must respect them, and their thoughts, their wisdom, for giving us a document, a living document, where we say that the rule of law and not the law of ruler. We live in a country where you have multiple judgments, 106 amendments in the Constitution, is starting from giving rights from day one to the citizens to the 33% reservation to the women, which was successfully passed in the parliament, and 10% EWS reservation. We have a country where we have the Supreme Court. Recently, we have seen the judgment with respect to the distribution of properties, distribution of materials, that what beautifully the Supreme Court has inculcated it. We have seen the Vikeshwanand Bharati judgment, where the Constitution and basic structure was made supreme. 2 years, 11 months, and 18 days marathon. Sir B.N. Ray, Dr. Ambedkar, Kamlapati Tripathi, K.M. Munshi, and all those who put forward, visited all over the world, brought the best thing and given us a document which is relevant, which is improvising every day. And Supreme Court is really the savior of the citizens of this country. Whenever the governments have failed to discharge their obligatory duties, the Supreme Court has come forward and protected the rights, liberties of citizens. We have seen it in various judgments, various constitutional judgments, be it Sabrimala, where the women were given rights, be it many other judgments in past we have seen. Friends, in 1860, Lord Macaulay brought a law which was based on the theory of giving punishment, and that was the Indian Penal Code, which should have been abolished way back when the Constitution was being framed, and when the Constituent Assembly members saw a vision that when the governments will come, will abolish it and will bring a law where the colonial patriarch mindset, colonial laws which were made to rule us on the theory of master-servant relationship will go, but it took 75 years. And my dear friends, my respected dignitaries on the dais, 77 times the criminal law was amended, but the law which was based on the colonial mindset was not abolished. Now, we have 3 laws, the BNS, the BNSS, and the Bharatiya Nyaya Suraksha, based this Bharatiya Sakshadhiniyam, where with the technology evolving, but the law was not evolving. We wanted a law which can deal with the terrorism. There was a separate law, POTA. There was a separate law, TADA. There is UAPA. But a law comprehensively to deal in a particular doctrine in a subject was not there. But here, the new definitions where the cross-border funding which will create or which will create unrest in the society, those people have, the law has inculcated to deal with those offenses. Also, the way society is moving, digital risk, digital arrest, deep fakes, artificial intelligence, we are seeing the side effects of this. Now we need a law to deal with that. The doctrine, the intermediary guidelines which were framed way back, that is not sufficient. We need the reformative law which is capable of dealing with those offenses. I have written a book, Article 32, where the more than 5,000 judgments delivered by the Supreme Court in order to protect the right and liberties of citizens have been passed. That book was, forewords were given by Honorable Justice Naveen Sinha. And another book, End of Colonial Laws, where I have summarized why there was a need to abolish those laws. That also forward has been given. So publicly, on behalf of all of you, and on my behalf, I acknowledge the efforts of Honorable Justice Sinha for reading 400 pages and writing a foreword. My friends, we have seen the situation of our neighboring countries, Bangladesh, Pakistan, Afghanistan, Iraq. We live in a country where diversity is there, but unity is there, where there are various laws, the personal laws, law derived from a parliament are in practice, but despite that, we are a great nation. So let's celebrate, let's feel proud to be part of a nation which not only practices the socialism in true letter and spirit, but also the courts come forward and define it from time to time. Thank you very much. Thank you for listening. Thank you.
Thank you so much, sir, for such an insightful session. May I please request Advocate Dr. Lalit Bhasin, sir, former President, Bar Association of India, and Managing Partner, Bhasin and Company, to please come forward for his presidential address. But before that, I request the technical team to play a short video about sir. So please.
Dr. Lalit Bhasin is a distinguished lawyer with over 5 decades of law practice. He started his law practice in 1962 and has developed Bhasin and Company as one of the leading law firms in India. Bhasin and Company currently maintains offices in New Delhi and Mumbai and has 28 associates. He is an honorable life member of the International Bar Association, chairman of Chartered Institute of Arbitrators, and a member of the ICC Arbitration India Core Group. He is the former president of the Inter-Pacific Bar Association and a former chairman of the Film Certification Appellate Tribunal of India. He was awarded honorary membership of the IBA in Melbourne in 1994 for outstanding service to the legal profession. Dr. Bhasin was awarded a Doctor of Laws honoris causa by Jaipur University in 2013. Dr. Bhasin was felicitated with a Plaque of Honor for outstanding contribution to the rule of law in 2002 by the Prime Minister of India, and the National Law Day Award in 2007 by the President of India. We warmly welcome Dr. Lalit Bhasin.
Thank you, sir.
I had never seen a film on myself, but thanks for sharing it with me. Honorable Justice Naveen Sinha, the worthy Vice Chancellor, Professor Chitnis, Dr. Purnima Inamdar, Professor Dere, my colleague Mr. Ashwini Dubey, other dignitaries, but most importantly, dear students. I bring to you greetings from the Bar Association of India, which is the apex body of the legal profession in the country. I also bring to you greetings from the Society of Indian Law Firms, which is a unique institution where only the topmost law firms of the country, they are admitted as members. We have about 130 law firms of India. And we do encourage young students, young lawyers, to do some internships with us so that there could be a meaningful interaction and a learning experience. It is learning experience not only for the students or the young lawyers, but a learning experience from ourselves also as lawyers. We gain a lot by that interaction because they are familiar with the latest technologies which are taking place, the various research tools which are now available, which were not available when I started my law practice in 1962. And I'm still used to that old system, you see, of reading the books, reading the law reports. I can't sit before a computer or a laptop to go through that. And I prepare my own submissions, generally by writing, handwriting, and sometimes giving dictation, because these days even good stenographers are not available. Everyone uses, you see, the technology. 10 minutes have been allotted to you, 2-3 minutes are already over, but I will not overreach, you see, because I am a strict disciplinarian so far as the time management is concerned, and that is what all the lawyers should learn also. And these days we are having pressing problems even from the courts that be brief, but certainly the lawyers, you know, they would like to not only impress their clients, but also to keep on making their points, you see, worth considering. And because brevity is an art which you young people must learn. And what you must learn is also a clarity of expression. Clarity of expression in making your point understandable to the honorable judges if you are appearing in the courts, but clarity of expression even in writing. That is what is being ignored, you see, by the law schools in India. Not much emphasis is given to legal writing. You see, when a file comes before the honorable judge in a litigation matter, he would first look into, okay, what is your case? What have you pleaded? What is the issue involved? Therefore, if there is no clarity of expression in your pleadings, in your writings, and then on the corporate side, again, while drafting such major conventions, protocols, bilateral agreements, mergers and acquisitions, joint venture agreements, there has to be a clear-cut clarity of expression. Therefore, expression oral and expression written, I think that should be the emphasis. Anyway, I have deviated from the subject. The theme today is law and peace. We see law, but we don't see peace. My friend Mr. Ashwani Dubey highlighted, you see, that how old laws have been replaced by new laws. But our Constitution recognizes, you see, those earlier laws also. There is a specific provision in the Constitution that those laws will prevail. And what is the entire basis of our Constitution? That is what we have inherited, you see, from the British. You see, England is a small country. It could afford the system of having 3-4 tier system. You first go to the lower court, then you go to the still somewhat higher court, then eventually you go to high court where again a single judge, then the division bench, then you go to the Supreme Court and all that. This sort of a luxury of litigation was not suited to a country like ours. But our Constitution has adopted this sort of administration of justice. But that can't be changed. One has to live with it because it is a part of the Constitution. And what has been done about these amendment of laws? I have had experience of looking into the famous 4 labor codes which have come. And I can tell you with some daring certainty that those are nothing but old laws, just, you see, put at one place in one code, second, another set of laws in second code. And what are these criminal law amendments? It is admitted position that 90% of the provisions are the same. There is only about 10% deviations and all that. Some of them may not even be conducive to our functioning of the criminal justice system. Therefore, let's not go into those controversies. We have to see how we can make the best use of our existing constitutional framework with nearly 500 crore cases pending all over India. In Pune only, I was sharing the dais. Mr. Dubey, that may be of some relevance to you. I was sharing the dais with the Honorable Chief Justice, former Chief Justice of India, Justice Chandrachud, in Symbiosis at their convocation. And the Honorable Chief Justice at that time highlighted how technology has moved, and you see what simplification has been done in the process of filing of the cases and filing of affidavits, evidence, pleadings, everything, virtual hearings, they have all taken place. So in my closing address, I pointed out to Justice Chandrachud that yes, that is very commendable what you have done, but one part of it has been totally ignored. What about the disposal of cases? Disposal of cases, can it be done by technology? Certainly not. No two cases are same. Facts of all the cases are different. Therefore, there has to be human intelligence and not artificial intelligence, which can be used for deciding the cases. But not much attention has been paid. Yes, technology is a good tool for research, but it is not a substitute, you see, for taking decisions on very important factual positions as well as legal positions. Each case has to be examined. These 5 crore cases have now, I am told by the Law Minister, Mr. Meghwal, that nearly now 6 crore cases are there because of simplification of filing cases. So it is a catch-22 situation. We have created ease of filing. We have not created ease of disposal of the cases. Citizens are suffering. So where is justice? Where is justice? You must have read, if not, please read the preamble to our Constitution. The very first preamble is, we people of India give to ourselves justice, social, political, economic. But is justice available to the citizens of this country? Emphasis is only on law. Law is just a part of justice. Justice is the overall thing, you see. And we have had this system of justice right from the ancient times. What is Panchayat system? It was not adversarial. It was consensuous. People used to meet. There were 5 wise men who used to sit, men and women. They used to decide mutually, and that was accepted. Same thing followed in the Zilla Parishads. Even during the Mughal times, if you have heard of that phrase, Adle Jahangir, Jahangir's justice, because there was no law at that time, it was only justice. Now you have, at the drop of the hat, new laws coming in. The parliament is passing, the state legislatures are passing new and new laws. New regulators come. Good for lawyers, because more regulators, more disputes. But bad for the country, bad for the economy of the country. Therefore, what has to be seen is that this law and peace, there is law, but there is no peace, which we have seen at the international level. You see the Ukraine-Russia, which is the crisis, which can any day become like a world war, nuclear war. You see the Israel and the Palestinian dispute which is going on. You see in India what is happening in Manipur, in Naxalite areas. Every day we read in the newspapers, so many Naxalites in Jammu and Kashmir also again attacks have started. You see terrorists attacked. So where is peace? Peace can only come if emphasis is shifted from law to justice. And that is what I conveyed to Professor Karad half an hour ago, that this law and peace, you make it justice and peace. And that is where the responsibility of the law schools come, to have this mindset in the people, in the students, to put more emphasis on justice rather than the reading of the bare acts and all that. That will come automatically to you. You do some research and all, you will know what are the principles of natural justice, what are the human rights and all. You will find it there. But evolve that sense of justice, which is very important. Therefore, there should be justice and peace, or at the most law, justice and peace. Justice can't be put in background. It has to come in the forefront. Our generation has failed, totally failed. We are responsible for, you see, breakdown of the system of administration of justice in this country with over 5-6 crore cases pending. You people with a new mindset. And how can you bring peace in your areas of functioning? That is the message I am giving to you. Promote settlements. Promote settlement of disputes. Let us go back to our ancient times. Settlements. Samjhauta. Whether it is family dispute, property dispute, any corporate disputes. I tell my clients, although I am deprived of them, depriving myself of my fee for appearing in courts, I tell them a bad settlement is better than successful litigation. That is what I tell everyone. And then you will gain the confidence of your client also in the long run, because the clients will feel and they will get impressed by the fact that you are acting in their interest in suggesting a settlement of the disputes. Therefore, promote this spirit. How do we promote peace in your area of litigation and disputes? Is by promoting settlements. So please keep that in mind. I am very happy to see such a large number of lady students here. And that is the trend in most of the law schools, because I visit almost 2 law schools every month as a part of my responsibility as head of some professional organizations. And I find that majority of the law students now are ladies. Young girls, they are studying law. That is a very favorable development, because ladies can definitely promote settlements. They are homemakers. Men can act as home breakers, but women cannot. They are homemakers, and they have enormous responsibilities than we men have. I just go to the court, prepare myself for the court hearings or meeting with the clients and all that, and 7 or 8 p.m. I come back. But my wife, who's also a lawyer, she's been nominated by the Chief Justice of India to the Gender Sensitization Committee of the Supreme Court. And she's not less busy than I am, but at the same time, she does not ignore the home front. So sometimes I marvel. She's a wife, she's a mother, she's also responsible for her parents, for my parents, and all that, you see, and what is to be cooked for lunch, what is to be cooked for dinner. How do we deal with our children? Enormous responsibilities. And I marvel, you see, at that, how women, lady lawyers, senior level, or even judges, how they manage that. I asked Justice Pratibha Singh, a very eminent lady judge of Delhi High Court. She says, oh yes, we try to do everything, you know, because it is in us. We can do it. And of course, then her husband was standing next to her. He helps me a lot, you see, for that. So thank you very much. It was a pleasure. But these 10 minutes are not enough for a good interaction. I think I've exceeded already 10 minutes, but there should be more time given if there has to be some meaningful interaction with such an important segment of our society, which is the future of this country. So give us more time in future. Thank you.
A big round of applause, everyone. Thank you so much, sir, for such an insightful and wonderful address on concept of justice and promoting peace through the lens of law. Thank you. As we move ahead, ladies and gentlemen, I now request our technical team to play a short film on Sant Shri Dhyaneshwara World Peace Prayer Hall and the World Peace Library, the World Peace Dome. The World Peace Dome is one of the biggest domes of the world, created with the vision of our honorable founder, revered Professor Dr. Vishwanath D. Karad, sir.
इक्कीसवीं शताब्दी में मेरी भारत माता विश्व गुरु बनने की काबिलियत रखता है. It will become a विश्व गुरु in the 21st century. उसका छोटा सा उदाहरण, छोटा सा सिंबल यहाँ बन गया है, ऐसा मेरा मानना है.
We have only two options. Either we live together or we perish together. It is in this context, this monument will stand.
We look at this magnificent dome. To me, this is not just the biggest dome in the world. To me, this is the biggest idea, the biggest message to the world.
This country has always propagated one thought, Vasudhaiva Kutumbakam, my dear friends. I must say that in the entire history after the independence since 1947, this is one of the unique steps towards the contribution of universal humanity. I appeal to the Vice President and Honorable Chief Minister to recognize this World Peace Dome as a structure of national and global importance and support to promote it in such a way that it evolves as one of the prominent tourism destinations of the world.
We should remember and respect like Professor Vishwanath Karad and millions of people like that, and remember the great service they have done. They should be remembered forever. That is also equally important for all of us. This is the message of this dome. This is the idea of the dome. This is the tallest, not only in size, but also in ideas.
Honored to have amongst us Honorable Justice Naveen Sinha sir former judge, the Supreme Court of India, for addressing today's gathering. I request the technical team to play the video about sir.
Justice Naveen Sinha is a distinguished judge in the Indian judiciary. He was appointed as a judge of the Supreme Court of India and has held several prominent judicial positions in his career. Prior to his elevation to the Supreme Court, he served as the Chief Justice of the Rajasthan High Court. Justice Sinha studied law from Delhi University and practiced in the Patna High Court for 23 years on civil, constitutional, labor, service, commercial, company and criminal matters. In 2004, he was appointed as a permanent judge of the Patna High Court. In July 2014, he was transferred to the Chhattisgarh High Court. He was elevated to the Supreme Court on February 17, 2017. Since his elevation to the Supreme Court, Justice Sinha has authored around 100 judgments in total. Out of these judgments, approximately 35% relate to criminal law. Justice Sinha is widely regarded for his balanced approach to justice, combining a respect for tradition with an openness to progressive legal thought. He has also disposed of a significant number of cases related to service law, criminal law, and property law. His judgments have often been noted for their clarity and depth, reflecting a commitment to justice and fairness. We warmly welcome Justice Naveen Sinha.
Come for the gathering and addressing the gathering. May I have a very big round of applause, ladies and gentlemen, for Justice Naveen Sinha, sir.
Dignitaries of the university in absentia, Shri Lalit Bhasin, Shri Ashwini Dubey, advocates, faculty members of the university on the dais, off the dais, and last but not the least, to my audience, the students. It's a pleasure to be here and to address you, the students, but there is one difficulty. The difficulty is that I belong to a generation very different from you. But I have the advantage of certain advantages over Mr. Lalit Bhasin and Ashwini Dubey, that I know the picture of the profession from both the sides, as a lawyer and as a judge. And I'll start off on a lighter note, then I'll come down to more serious things. See, when I was made the Chief Justice of the Chhattisgarh High Court, as in my capacity as the Chief Justice, I was also the Chancellor of the Hidayatullah National Law University. So the first time I went to address the students, like I'm addressing you people, I said that I don't know whether to envy you people or to pity you people. But standing here as a Chief Justice, it is safer for me to say that I envy you people, because if I say I pity you people, the next question one of you will ask me is, how the hell did you become a Chief Justice? The reason I say that is that education in the field of law has undergone a sea change ever since I did law. I think it was more or less the same when Mr. Bhasin would have done law. You see, in my generation, and same thing goes for Mr. Bhasin's generation also, I think you said right, time is too short, so we'll have to compress everything. See, law was not a choice for a career. The choice was either an engineer or a doctor. Only those people who became lawyers were people who couldn't decide what to do, or they were considered good for nothing. So in the same category, I sort of drifted into law. And they were a 3-year course. Now you people are more fortunate. your method of, starting with admissions. I just walked into the law faculty of the Delhi University. There was no crowd at the counter at all. Just slipped in my form, paid the fees, and my admission was done. Now, you people have had a much tougher period. I was told today that even this university conducts an examination and a screening process for granting admissions. All these things were not there earlier. Combine that with a more strenuous way of studying law. We had what was called in the law faculty, we were given printed materials of case laws, and the questions would invariably be from those. So life was very easy. It hardly required much study. Whereas you people have much more difficulty. You have moot courts, you have to prepare cases, and therefore, what Mr. Bhasin said is very important for you. I'll just come to what he said. Number one, I'll start off with, because you are all students, tomorrow you'll be stepping out into the world. So I'll try to cover that spectrum of your life. And based on my experiences as a lawyer, as a judge, having seen the legal profession from both sides over all these years, about 23 years as a lawyer and about 17 and a half years as a judge. See, the law profession compasses, when you finish from here, you have various options. One, you can go become a lawyer standing in the courtroom. Many of you will go to the district courts. Many of you will come to the High Court. Speaking for myself, I would not suggest starting from the Supreme Court. And I can't explain to you here, but that would be my advice to you, because you have to learn, number one. Number two, as Mr. Bhasin pointed out, yes, he's very correct. The number of girls in the legal education is increasing, and it is being reflected very strongly in the judicial services of the states. I can say definitely for 2 states. I have experience of 3 states, my home state, Patna, Chhattisgarh, and Rajasthan. There has been a sudden quantum jump in girls qualifying in judicial services examination and becoming good judicial officers. Even for the boys, it's a very good option now. The service conditions are very different. It gives you dignity, it gives you security, it gives you a good salary, and you have career prospects there also. The advantage is that unlike a lawyer, you have to put in very hard work, and it takes time. Even as a judge, you have to put in hard work, but then you do get a monthly remuneration. The third would be that you can go to the corporate world, where a lot of companies are keeping their own counsel now. Then you can go in for academics. So it's a very wide field open for you. You have to decide what you want to do. But the basic thing would be, you want to become a good lawyer or a good legal counsel? The first thing is to keep in mind not to compromise in situations where the values and the principles that your parents taught you become challenges for you. Don't succumb to those challenges. Don't look for shortcuts. You know what happens when you go trekking into the jungle and you leave the beaten track where all trekkers take and you try to chart out a new path for yourself, you get lost. So do not try to do that. Never compromise in things that you believe in. Number one. Number two, I'm trying to compress as much as I can. Number two, what Mr. Bhasin was pointing out, I'll build it up a little more. He's talked of brevity, clarity, verbosity. He couldn't have been more right. He talked of technology. Technology is proving to be a boon, a bane, not a boon. And I say that both from the perspective of a lawyer and a judge both. You see, at least when I was in school, and I saw this difference between me and my colleagues as a lawyer and me and my colleagues as a judge. When I was in school, we had a separate subject called Pressy writing. And I think that is where I picked up this knack or clarity of thinking. When you are writing, you don't have to be so brief that you miss out the point. But don't be so lengthy. Don't be so lengthy that the reader flips over pages, 1 page, 2 page, 3 page, and then says, this person is writing the same thing. And the real point is probably on the 8th page, which should have been on the 2nd page. Number one. Number two, when you are speaking, yes, you must know when to speak. And this applies throughout, not only in the courtroom. Even if you are a judge or you are working in a corporate world, you should know when to speak based on your preparation, know when to speak, when not to speak, and how much to speak. Right? And the third would be getting a combination of reading, writing, and speaking. Because if there is no clarity of thinking, you might have the best point, you might have done an excellent draft, you might have done your preparation excellent, all thoughts in your mind. You stand up in the courtroom or wherever you are addressing, there is no, I will say there is no interconnection between your writing, your thinking, and your speaking. So what comes out is a jumbled speech where things are not sorted out as to which should be said first, which should be said second, which should be said third. Now technology, yes, technology is a very big boon, but don't depend on technology. You can see the results, lawyers filing voluminous briefs, as Mr. Bhasin pointed out, that the ease of filing has had a counter effect. He's very correct. Because everything now is available at the click of a button, so the copy-paste theory has come in. And the copy-paste theory is coming into judgments also. And therefore you find very lengthy judgments. So don't get into that. And as far as the internet is concerned, yes, as Mr. Bhasin pointed out, make it a starting point of your investigation or inquiry, not the concluding point, not the concluding source. And don't be in a hurry. If you want to come into the legal profession, those who go to a district court, those who come to the high court, they will face different kind of challenges, and they will have to meet up with different kind of challenges in the different courts. So what is good for Delhi or Bombay is not necessarily good for a lawyer practicing in a district court. So please don't be intimidated by those things. And one more thing, yes, we were talking about justice. I very firmly believe, and this is not my original thinking, but I had read it somewhere, I can't remember where I had read it. It says, courts do not dispense justice. Courts interpret the law. What follows from the interpretation of the law is justice. And therefore the old saying that what is justice for one may work out to be injustice for the other, but it can't be helped. There are situations like that. And yes, as lawyers, as a student of law, my suggestion to you also would be, because it has helped me a lot, my suggestion to you would be that please do not have a myopic vision that you are in the field of law. To be successful in the field of law, you must have what is called in English language, simple English language, a smattering of a knowledge of other subjects. And I'll give you a very small example. Again, my personal experience, destiny of the litigant, and God's will. That's the only way I can put it. See, we heard a case in the Supreme Court in the summer vacations. It was a conviction under 302. I was the junior judge. I had just been appointed to the Supreme Court. So in the courtroom, we told the lawyer, there's nothing in your case, we are dismissing it. So we reserved the order, and then my brother judge told me, you write it. So I said, all right. Now again, it was destiny. Had it been, the pressure of work is so much that if it had been a normal working week, going by the set parameters of criminal law, we would have probably dismissed it as we had observed in court. But when I was reading the translation, since we were in the vacations, I called for the original files. I was reading it. And of course, translations are pretty bad, done locally. I found a line which substantiated the defense of temporary insanity. I'm cutting it short. So the original evidence was all in Marathi. Now my wife happens to be from Bombay. So I asked her to read it out to me in Hindi line by line. And what I was looking for of temporary insanity, coming from a disease called epilepsy, which had different manifestations. A person loses control over his self. Now this was something which the trial court missed out, the higher court missed out, we were also missing it out on the Supreme Court. This is just an example, there can be numerous examples. So widen your base of knowledge so that you have an idea of everything. And then you can start your research. And the last, but not the least, yes, I would certainly recommend all of you to read Ashwini's book, especially on the criminal law. What people are missing out is what Mr. Bhasin said. I'll have a slight difference of opinion. Yes, it contains most of the old laws. There is no doubt about it, because crime is crime, and most of the crimes have been explained there. But what that book deals with, and that is why I'll suggest all of you to read it as students of the law, because I believe his book is very good for law students and the common man. See, there are a lot of, as society evolves, crime also evolves. Now, there are a lot of crimes which didn't exist earlier. The same crimes which are earlier mentioned, they are coming in different dimensions. These are aspects which the new law deals with. And I'll request all of you to read it. And for the students, why was the legal profession called a noble profession? It was called nobles because in the Roman times, you see, I don't know if you've noticed the lawyers wearing gowns, it has a small pouch at the back. That pouch signifies that they didn't even charge fees. Whatever the clients gave behind their back, that was their income. Because they were doing something in the interest of the society for the people. Therefore, now just before I wind up, sensitizing legal professionals through the lens of law to bring peace. Only one piece of advice, what Mr. Bhasin said, I'll expand on that. I wish I could have spoken to you more. But as I said in the beginning, be honest to yourself, be honest to the client. It may take away one client because you told the client that he doesn't have a good case worth going to court. The moment he goes to court and he loses, because some other lawyer picked up where you said you don't have a case, that client will then remember you. He very rightly said that. So play long, don't play for shortcuts. And I think that is all. I will wind up here. And only one story, what Justice Bhasin pointed out, especially for the young ladies present here. I was taking an interview for judicial officers. That is the new generation. That is why I'm telling that story. This was in 2014. I was taking interviews for the post of a judicial officer. And there was this young lady, and I asked her that, why should I select you? And exactly the same reasons what Mr. Bhasin said. I said, I'll recruit you, I'll train you, I'll spend so much of money on you. Tomorrow your parents will get you married, and your husband may be somewhere else, etc., etc., etc. So why shouldn't I give this to a man who probably needs the money more to run a family? And I think that girl epitomizes the new generation. She said, sir, I am not taking away anybody's job. The Constitution guarantees me equality. Right? And I think there couldn't be a better anecdote for the young ladies present here in this 75th year. when on the 26th of this month we are celebrating the Constitution Day. Thank you.
Thank you so much, sir. May I request everyone to please stand for a standing ovation for Justice Naveen Sinha, sir. Thank you so much, sir, for guiding our students. Indeed, it was a wonderful talk by sir on guiding our students on developing skills of critical thinking, writing and articulation, as well as widening their corpus of knowledge on other subjects, especially other than law. Thank you so much, sir. As we proceed towards the conclusion of the 4th International Symposium on Law and Peace 2024, the completion of this two-day mega event would be incomplete without having a glimpse of the thoughtful discussions done on this platform to herald, promote peace through the lens of law. Therefore, I request my technical team to play glimpses of the 4th International Symposium on Law and Peace 2024.
We are talking about the world peace, and the law is one of the important medium, I think, for all of us, not today, but from ages.
The rule of law is the glue that holds the promise of peace together.
The concept of peace of a citizen should not be self-centered or self-centric.
The basic function of law is to promote and to provide mutual security and mutual benefit.
Promoting rule of law and to ensure justice for all is the key to achieve peace.
The rule of law of any nation must run to the close of life of the people, and the rule of the life of the people who make themselves must run close to the rule of Mother Nature, because the rule of Mother Nature is common for all.
I am delighted to address students of the School of Law of MIT World Peace University in Pune. Please remember this, that in the legal profession, good luck and loads of it invariably follows upon hard and strenuous work. And I wish you all the best of luck.
Thank you so much, team. Through this video, we also extend our tribute to late Shri Fali Nariman Sir, Senior Advocate, Supreme Court of India, as he addressed us in our 3rd edition of International Symposium on Law and Peace. Thank you. Now, I request all the students and the dignitaries to please stand as I'm going to administer the oath. I request everyone to please put their right hand forward and repeat after me. Please put your right hand forward, ladies and gentlemen. Thank you. On the platform of MITWPU's International Symposium on Law and Peace, we, the sons and daughters of Mother Earth, being the global citizens, are sure to abide by the duties and responsibilities of an ideal citizen, and hereby affirm that we will endeavor to promote peace and harmony through the lens of law in the pursuit of justice. Thank you. As we proceed further towards the conclusion of our today's valedictory session, it is my privilege to invite our Chief Academic Officer of MIT World Peace University, Dr. Sanjay Kamtekar Sir, for the concluding remarks and vote of thanks.
So good evening, everyone. What a remarkable last 2 days are. We heard them all, some of the veterans in the field of law and justice and peace, and some of the new trailblazers. So first and foremost, I extend my heartfelt gratitude to our distinguished guests for gracing this occasion with their presence. First, I'll start with thanking our president founder, Dr. Vishwanath Karad sir, whose vision continues to inspire us, Sri Rahul Karad sir, for his unwavering support and leadership, Dr. Chitnis, our Vice Chancellor of MITWPU, for guiding the academic excellence of this institution, Justice Naveen Sinha, former judge of the Supreme Court of India, for sharing invaluable insights into the judiciary evolving role, Dr. Lalit Bhasin, former president of the Bar Association of India, for contributing his extensive expertise in legal reforms. Last but not least, Advocate Ashwani Kumar Dubey, advocate in Honorable Supreme Court of India, for sharing his deep knowledge and practical perspectives on evolving landscape of legal practices. So your participation has elevated the quality and discussions and enriched this international symposium on law and peace. A special thanks goes to our dedicated faculty members who have worked tirelessly to organize this event, and to our students whose enthusiasm and engagement were instrumental in making this event and symposium impactful. This gathering has explored vital themes that resonate deeply with the legal and societal challenges of our time The integration of AI in legal education and practice, the modernization of criminal law, and the pursuit of gender justice are not just academic topics, but pressing issues shaping the future of justice delivery in India and beyond. These are the really pressing issues internationally, in different countries, different societies. Your contributions during the sessions have underscored the importance of collaborations in addressing these challenges, whether it's reforming outdated laws, ensuring inclusivity, or addressing global issues like climate change and international conflicts. It is clear that the law must evolve to stay relevant and just. This cannot be underscored by evolving digital world we are living in. As we close this symposium, let us carry forward insights shared here and channel them into actions. Each one of us has a role to play in shaping a legal framework that is equitable, inclusive, and forward-thinking. Thank you once again for your valuable contribution, and I look forward to seeing the positive changes that will emerge from the discussions we have over these last 2 days. Wishing you all success in your endeavors. Thank you once again, and God bless you. Thank you.
Thank you so much, sir, for your address. I now request everyone to please stand for the national anthem as we officially proceed towards the conclusion of this valedictory session. Thank you. With this, we officially conclude the 4th International Symposium on Law and Peace 2024. And I thank everyone for making this event a grand success. I request all the dignitaries to please proceed downstairs for a group photograph with our students. I ask these students to please stand up at their seats as the dignitaries will proceed downstairs for a group photograph with you all. Thank you.